Good morning. Good morning. It's Thursday. It's February 15th. It's our law-nerd friend Amy Van Dyken's birthday. We have lots to talk about today. We're going to be talking about all of the motions going on in the Petito Laundrie civil case. There's a ton of new filings between February 12th and February 14th. So we're going to go through some of those things today. So that's what we're doing today. It's not going to be the world's longest stream, fingers crossed. I'm still under the weather, so we are hanging in there, but we've got a whole bunch of motions for summary judgment to go through. Those motions tend to be pretty extensive and long. They have lots of exhibits, so it's going to be lots and lots of information. So let's roll the intro and get on into it. Law nerds, it's good to see you. It's good to see you. It's been I streamed yesterday. We did the podcast. I streamed. I picked up my kiddo from school and went to bed. That was a happy Valentine's Day. Everybody in the house except for G is sick, so it's just. Let's roll the intro and let's get into it.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
I saw the super chat from Casey Cat. I know Kansas City is absolutely reeling. I am thinking of all of you guys in Kansas City. I think that news was breaking while I was streaming because I didn't see it till later in the day. I don't look at breaking news while I'm streaming. It can derail the stream, but all of you that are coming in from Kansas City and surrounding areas, we are absolutely thinking of you. We are going to get into, because there's not really much more to say other than it's horrific, but I don't cover breaking news. I'm so much more comfortable. So chat, I love seeing you guys send absolute love to all of those in Kansas City. We are going to focus on the Petito and the Laundrie filings today because I truly don't cover breaking news because I'm a legal commentator and I can help you guys parse through legal documents. The emotional parsing through of tragedies is a little bit harder, other than to say you guys aren't alone. And it's absolutely heartbreaking. So for those of you that aren't up to speed on the Petito Laundrie case, I'm going to do a little bit of a road so far on the civil case. This is a hard one, and it's a difficult case because it requires us in a very hard circumstance to really explore legality and morality. Because the way that this lawsuit is unfolding and the way that the civil laws are being used is novel and new, and the law might really not stretch this way, but it doesn't mean we like what happened. So it's a difficult case to take like the emotional morality side of like fuck this shit and the legal side of but the law actually might not give remedy here, and have those conversations next to each other and understanding that the law doesn't always remedy the things that have gone wrong. And that is something that can be frustrating because in the Petito Laundrie situation where we're dealing with the parents, there's not a lot of ways under the law to make this right. It remains my opinion that the entire case was filed for the Petito family, and I call them the Petito family. Gabby Petito's mother's last name is Schmidt. I will continue to call them the Petito family just because we've got the Petitos, the Laundries, and Bertolino, and otherwise it gets very confusing. No disrespect is intended. It's just that is the family Petito. So after Gabby Petito went missing, I think the Petitos knew that the Laundries had information that they did not disclose. Of course, they are outraged about that. How could you not be? The betrayal there is massive. These are Gabby Petito and Brian Laundrie are fairly young adults that were engaged, and these families that were looking at becoming a family through the wedding, and a family through being being in-laws. So when Gabby Petito goes missing and the Laundrie family is radio silent and then blocks the phone numbers, I can't quite fathom the depth of the pain that that would cause. I don't know if the law, especially in the realm of intentional infliction of emotional distress, remedies that wrong and that betrayal. I don't know if the law used this way is going to get there. What the law can do is provide answers, and we're going to see some of those in these motions for summary judgment because all of the depositions have been done. I know that JB over on WFLA did a very extensive piece after reading through all of the depositions. I have not read all of the depositions yet. We're going to go through the motions for summary judgment today. What are motions for summary judgment? Motions for summary judgment are saying, hey, Your Honor, this is all the evidence that's going to come forward, but as a matter of law, there is no triable question of fact for a jury. Juries are fact finders. Judge determines the law, jury determines the facts. Hey, Your Honor, there's no facts left. We just went through this earlier this week with the TikTok psychic defamation case, where I'm going to save this question. Jennifer, I'm going to save this question because it's a good question, and we will get to it. In the TikTok psychic case, the professor is saying, Your Honor, she said that she said it. She said that she has no basis in fact for saying it. It's defamatory. What is there for a jury to determine? Like, it is what it is. And that's what's going on here, is those motions for summary judgment, arguing to the judge, hey, now that we've done discovery, now that we've got the facts, the judge can look at the facts and determine if there is a triable issue of fact for a jury. Can the jury hear this case? And that's where we're at today. So those motions are brought by the defendants. We have one motion for summary judgment brought by the lawyer, Stephen Bertolino, and one motion for summary judgment brought by the Laundries. So we're going to go through both of those motions for summary judgment. I imagine they're going to be substantially similar. We're not going to go through all of the depositions today. If you would like to go through the depositions, we will go through the depositions. So I don't know if the law is going to be the right remedy for this. We'll see. I've never seen, and I've not talked to a lawyer that's ever seen intentional infliction of emotional distress used that way. It is a difficult case because the Laundries didn't owe a duty of any kind to the Petito family. Are there moral duties to be a decent human? Yes, but those aren't legal duties. So there's no legal duty that requires the Laundries to speak up or to say something to the Petitos. If they had said nothing, this case would never have been brought. The reason this case was brought was because of a statement made by Stephen Bertolino. We'll get into that here. And we saw at the very beginning of this case, this judge talking about the Johnny Depp Amber Heard case, because in that case, you had Johnny Depp being tried for statements made by a lawyer on his behalf. But Johnny Depp was the one on trial for statements presumably the lawyer made on his behalf. I think that would have been very interesting to have followed on appeal, but the appeal got settled. We'll never know. But here it's a reverse situation where Stephen Bertolino was speaking on behalf of his clients, but he's being held responsible for the things he said. And that is also not something you normally see. You would normally see that agent, the lawyer, you would see their statements pass through to the client. So we might end up with different results on the motions for summary judgment in this case. We could end up with one result as to Stephen Bertolino and a different result as to the Laundries. And that is legally possible, and it wouldn't be the weirdest shit I've ever seen. So this is a factually novel case in the way that it's being used. But that doesn't mean that it's not, that there doesn't feel like a like moral justification that needs to happen here, right? The behavior outrages people, but does that mean it's legally improper behavior? And that's where this case gets so difficult to talk about, because I think all of us sit here and look at the behavior of the Laundries and are like, what are you doing? But does it hold you to the level of civil liability? And I don't know the answer to that. And I'm not going to sit here and say, yes, I think it holds you to civil liability, because I'm truly not sure that is what the law this is what the law intended with intentional infliction of emotional distress, which is why I think it's important to continue to talk about it, because this is one of the starkest examples I think we've seen of morality legality, and how we have to have kind of two minds when approaching this case, and put the feelings to the side, and put all of the like the you suck to this side, and then evaluate the law on this side. It's not always an easy thing to do. So just keep that in mind as we go through this and talk about the law, because ultimately a jury in the state of Florida might get to decide, does the law in Florida allow for intentional infliction of emotional distress to be used this way? And are they're the ones that are allowed to put the bumpers on it. If this goes to trial, if this gets past summary judgment, if the Laundrie families or Stephen Bertolino are found liable, this case is going to be on appeal for 10 forevers. So even though this is going to trial, or should be going to trial in May, again, if the motions for summary judgment don't cut this case down, and stop it at summary judgment, if this goes to trial, it's going to be very interesting to see what a jury does, because this is a very emotionally charged case. You bring in that letter that Roberta Laundrie wrote, the burn after reading letter, and I can't imagine how a juror gets past, okay, but what's the ins and outs of the law? How do you get past the, okay, yeah, but fuck you. You're like, I'll bury a body for you. What? How do you get past that as a juror in this case to really delve into the nuances of whether this is actually intentional infliction of emotional distress or not? That's hard. If this goes to trial, it's going to be very, very difficult. So, Lawnards, let's get into these motions for summary judgment. We're going to go through the Bertolino one first. Lyndon said, see, Kohlberg stages of moral reasoning, great model for morality versus legality. Love the recommendation. Absolutely love it. Thank you to everybody who's gifted memberships. Love it. It's a really difficult case, and that does not ever undercut the emotional weight of this case. This is a legally difficult case. So I know y'all are law nerds, and y'all can be like, the emotional weight of this case is one thing and the legal weight of this case is another thing. We're going to jump into the legal weight of it today and see what we know. It might just make us more mad. I don't know. I have not gone through what I'm sure is fine and thorough reporting by JB, because yesterday I did the podcast with y'all. I streamed, I picked up my kid, and I went immediately to bed because I'm still not feeling great. I did see a lot of you ask in the chat, and I appreciate how tuned in you are to me as a basic bitch human. Yes, I did get my Chroma Stanley mug this morning. Yes, I set the stream to start 15 minutes later so that I could buy the Chroma black and iridescent oil slick Stanley mug. It's like the Stanley was like, if Emily was a mug, what would it look like? So I will share that with you when I get it. I didn't get both of the ones I wanted. I got one of the ones I wanted. I got the Super Soaker mug thing, which I love, but I didn't get there was a water bottle that sold out while it was in my cart waiting in line. And I was like, both of the things were in my cart and I'm waiting for checkout. Stanley, by the way, uses Shopify. So I'm waiting in the Shopify line for the checkout, and the one went unavailable, and I was like, oh. So I was sad by that. But I love the I'm very excited to get the black, and then this is like oil slick chrome, and this is oil slick chrome. When I wrap my car, that is what it is going to look like. We're going to have pops of oil slick iridescent, and then this poor mug will go on a shelf somewhere and be super sad, because as much as I love the watercolor, black and iridescent is the color of my soul. All right, y'all ready? Are y'all ready? Stacy said, I haven't been getting notified for the BTS streams. I did not do one last week because I was sick. So if you did not get a notification last week, I did not do one last week because I was sick. So the oil slick is $120 on eBay. I don't know, man. I don't think this is going to be the only release of this. I think they'll do another release. Would I pay $120 on it? I don't think so. You got the dark unicorn mug. Yes. My soul. EDB, I saw a white Chanel bag with oil slick hardware yesterday in store. Your girl was tempted. It's hard. I can't do white bags. I have one white and oil slick bag, and I have carried it once because I'm terrified of it. I need it to be black. I wear so much black that if I carry white handbags, they get black. They end up with color transfer from my clothes. All right. Let us go. Let us talk about this. I've been very this worked really well yesterday. I love that StreamYard lets me like mess with it like in real time. This worked really well for me yesterday. When we were going over the video, it was great, but I need to Emily, how often do you change your layout? Look, man, I'm ADHD. You know how you need to like spend 2 or 3 hours to like build the perfect playlist or find the perfect movie to put on in the background when you need to do a task that you don't want to do? This is where I'm at with this. So let's get into this motion for summary judgment, and then we will get to, you guys, I see your questions about the Crumbly case vis-a-vis this case. We're going to talk about that. I'm going to speak to that when we get done with these motions for summary judgment. I will say, as a matter off the top, this is a Florida case, that is a Michigan case, and they are very different. This is a civil case, that is a criminal case. So just keep in mind that these are very different things. Okay, thank you, StreamYard, for letting me mess around literally with my layout every single time I stream now, because that's what we do. We like any of my other neurodivergent folks like wiggly. You got to just get into your vibe for a minute before you can start. That's me messing around with my layouts on StreamYard. All right, let's go. This is defendant Stephen Bertolino. God, I burned my finger this morning making breakfast too. Like, today's been a whole day. Today's been like a whole day. And Dr. B is like, you okay? And I'm like, no. And he's like, anything we can do about it? I'm like, also no. All right, let's see. Defendant Stephen Bertolino's motion for summary judgment. Introduction. This is a cause of action based in alleged intentional infliction of emotional distress. The alleged wrongful conduct is speech concerning a public issue, more particularly press releases. There we go. Issued by Mr. Bertolino in his capacity as attorney for defendants Christopher Laundrie and Roberta Laundrie. The statements were made at a time when plaintiff's daughter, Gabby Petito, was missing, and plaintiffs initiated a massive public awareness campaign to publicize their daughter's disappearance and seek help in locating her. Accurate. I think that's accurate and not sensationalized. The public awareness campaign resulted in significant public attention and scrutiny directed towards the Laundrie parents. Oh, well, now we disagree. I think that existed before and apart and aside from anything the Petito parents did. I would love to know what you think in the chat, but I think the public scrutiny and attention on the Laundries started before the Petitos ever spoke in public. You guys, is Amy in the chat? I see Amy Van Dyken in the chat. You guys, will you wish my friend Amy happy birthday? Cause it's her birthday. Thank you. I think the public scrutiny started before the Petito parents ever spoke publicly. Oh, my computer's being weird. No, now's not the time to install things, computer. It goes on in footnote 1 to say Miss Petito was traveling with the Laundrie parents' son, Brian Laundrie, at the time she went missing. Yes, yes. Part of the plaintiff's public awareness campaign sought to emphasize that the Laundrie parents had information about Miss Petito's disappearance. Disagree. And this is me going from my memory. And again, this is Stephen Bertolino writing a motion in an advocacy fashion in the way most favorable to them, well, his lawyers, to get the court to dismiss the case against him. That's what he's doing. So me interjecting disagree is just how my brain processes information when I read it. Because I don't agree with their positioning of this fact. They emphasized that the Laundrie parents had information about Petito's disappearance, which they were not sharing. I think they asked that question. I don't think they emphasized that. They said, if you know anything, tell us. That's my memory of it. This premise that the Laundrie parents knew something and refused to talk quickly gained traction in the public discourse. People believe that. It's my memory. People believed that before the Petitos ever spoke, because Brian Laundrie came back to Florida with the van that was both of theirs without Gabby Petito. Those actions caused the public to go, excuse me, what now? Before the Petitos said anything. Quickly gained traction in the public discourse, and the disappearance of Miss Petito became widely reported. It was widely reported before the Petitos spoke. Amy, thank you for gifting memberships. I love that you're giving us gifts for your birthday. Thank you. Thank you. Allie, I will absolutely give you a goat as we get into a break between the documents. We'll go. Tina said the van, I think the van was actually hers. The van was hers. He came back with the van, though they were engaged. So there's some conversation about the van, but the van was hers. The van returned. He returned. She did not. Public discourse discuss before the Petito said anything. I'm finishing my coffee. Hopefully you are too. And I've got to move it out of the way because the bird feeder has made my desk part of the kitty cat racetrack. Mr. Bertolino is now being sued for IIED with respect to 2 press releases issued on behalf of the Laundrie parents during that same time, one on September 14th, one on September 19th. The statement at issues were defensive in nature, they say. Issued publicly for the purpose of responding to significant public pressure and demands that the Laundrie parents say, quote unquote, something and explain their silence, which again, they are not obligated to do. They were not obligated to say shit. I don't know how uncomfortable this must have been for them because people were like camped outside of the Laundrie's home screaming at them all the time. And then their daughter spoke up about the fact that they had all gone camping together. Like this case got real weird before Gabby Petito was found, before Brian Laundrie was found. And then very weird in the time between when Gabby Petito was found and identified and when Brian Laundrie was later found and identified. Specifically, it goes on to argue on September 14th, the Laundrie parents, through Bertolino, acknowledged it was a difficult time for both families, expressing hope that the search for Miss Petito would be successful and that she would be reunited with her family, and explained that the Laundrie family would be remaining in the background and would have no further comment on advice of counsel. And during this entire time, Bertolino didn't stop talking either. Like Bertolino was texting news anchors. Bertolino was very chatty during this period of time. By my memory. On September 19th, upon discovery of Miss Petito's remains, the Laundrie parents, through Bertolino, stated the news about Miss Petito was heartbreaking and that the Laundrie family was praying for Miss Petito and her family. The instant litigation plaintiffs allege it was beyond outrageous for the collective defendants to remain silent. I don't think that's a cause of action. I don't think you can intentionally inflict emotional distress on someone by remaining silent. I don't think that legally follows. But that's not all that they're suing over. They're suing over the statement about hoping that the search would be successful and that she would be reunited with her family. That's the crux of this case. We're going to have to look at the language in this case as closely as we look at language in like a defamation case, because the argument here is that expressing hope that that the search for Petito would be successful and she would be reunited with her family. The Petito family is alleging that statement gave them hope that she was still alive because they believed the Laundries had other information, and that if the Laundries knew she was already deceased, that making that statement was cruel because that statement was giving them hope that she would successfully be found alive. This puts Bertolino and the Laundries in the worst legal position you can be in, where they have to argue that what the statement meant is that they hope that she would be found, whether alive or dead, and that they hope she would be reunited, whether alive or in remains. You don't want to be the lawyer standing in court arguing that this statement means we hope that her body would be found. Like, that's never where you want to be as a lawyer. So that's the argument they're going to have to make. That reunited means whether it's reunited alive or reunited in remains, or reunited one day in the afterlife when they've all passed away. That's the position that the Bertolinos and the Laundries are in, that they have to argue that. That's a shit position to be in front of a jury. And then you add that burn after reading letter, and that is an awful position for the lawyers to be in, but that's the position the lawyers are in. How do you look at a jury and argue that? In this circumstance, how do you look at a jury and go, I mean, they never said they hope she was found alive. No lawyer wants to argue that. And if this goes to trial, they're going to have to. It's a little easier to argue in front of the judge, because in front of the judge, the arguing the legal nuance can be done a little bit better with a straight face, because you're talking to the judge about legal nuance. Then you can argue that to a jury. Let's see. In the litigations, the plaintiffs alleged that it was beyond outrageous for the collective defendants to remain silent. I don't think there's a cause of action for that. And then express hope that Petito would be reunited with her family when they purportedly knew that she was deceased and where her body was located. I don't think the silence is actionable. Whether the statement is actionable is not super easy to answer. And that's what this judge is going to have to do. Plaintiffs argue that issuing the statements, the collective defendants engaged in conduct that was intentional or reckless, and they should have known the statements would cause emotional distress, and knew or should have known that plaintiffs would likely suffer emotional distress from the statements. And then this puts the defendants, the Laundries and Bertolino, in the position where they're going to have to argue, if this goes to a jury, they're going to have to argue they were distressed over their daughter being missing, not over the shit that we said. Also a terrible position to be in if you are those lawyers. As explained in detail below, the undisputed material facts demonstrate there was no intent to cause emotional distress. It doesn't have to be intentional, because they're also arguing the reckless element. Is it reckless to make this statement if you can prove that the Laundries knew and Bertolino knew that Brian had already murdered Gabby Petito? Is that a reckless statement? And that's why focusing so much on that phone call with Brian Laundrie, where he called and said, allegedly, based on the depositions, he called and said, I need a lawyer. I need a criminal lawyer, and Gabby's gone. So from the date of that phone call, wouldn't they have known? Kristen asked a great question in the chat. I'm confused. I thought Bertolino was the attorney for Brian at that time. I need to make sure that I can move here. Let's do this. That makes me a little easier to see. Yay. it has been accepted in this case that that Bertolino was also the lawyer for the Laundrie parents at this time. That has been accepted as fact. So no one has argued that he wasn't their lawyer. Everyone has argued that Bertolino was their lawyer at the time. Let's see. As explained in detail below, the undisputed material facts demonstrate there was no intent to cause emotional distress to either plaintiff, nor was the creation and dissemination of the statements reckless. The record does not support plaintiff's theory of outrageousness or establish legal causation. While plaintiffs have understandably suffered extreme emotional distress as a result from the loss of their daughter, there is no objective evidence upon which a reasonable jury can rely to determine that the statements at issue caused measurable and redressable emotional injury. Again, making that argument that they were distressed, but they were distressed because their daughter was missing and then deceased, not because of the statements they made. No reasonable jury could return a verdict for plaintiffs on their IIED claim against Bertolino, and therefore summary judgment in favor of Bertolino on counts 3 and 6 of the plaintiff's third amended complaint is required. Beyond the lack of evidence, the public policy implications of plaintiff's claims, as well as the application of the First Amendment, require entry of summary judgment in Bertolino's favor, as detailed below. The statements at issue dealt with matters of public concern because they related to a significant concern of the community, which was subject of legitimate and substantial news interest. Speech on matters of public concern, like statements at issue here, are at the heart of the First Amendment, and therefore cannot form the basis for an IIED claim. For this additional reason, summary judgment is appropriate. Let's go through the facts. Before we get to the facts, the subject statements are afforded qualified immunity under litigation immunity privilege because plaintiffs have not and cannot show malice on the part of Mr. Bertolino in issuing the same. The claims are precluded and summary judgment in favor of Bertolino is required. And this is where Bertolino's in a different position than the Laundries, right? Bertolino is acting as their agent and their lawyer. Can he be sued for releasing a press release, making a statement about a case that is his client's case? I don't know if there's litigation here, though, because he's not anticipating, I don't think, that the Laundries are going to be arrested. There's no civil litigation pending. So I don't know if we're in the gambit of litigation immunity privilege, even though he was representing his clients. I don't know if we're there. Undisputed material facts. Petito and Brian began dating in 2019 and became engaged. Throughout the tenure of their dating and engagement history and up to August 12th, 2021, there was no known history of abuse or physical violence between Petito and Brian. We'll see what the responses to that have to say. Based on interactions between Brian and Petito's family, Brian was observed to be a nice individual. These are all, as you guys are watching this, they're telling you at each sentence of their facts where those things come from. This comes from the Petito deposition and the Schmidt deposition. The Petito deposition is Gabby's father. The Schmidt deposition is Gabby's mother. So these are a summary of things that were said in those depositions. Based upon interactions between Brian and Petito's family, Brian was observed to be a nice individual. Schmidt deposition. Throughout the time that Gabby and Brian knew each other and or had a relationship, Joseph Petito never met or spoke with Brian's parents. Deposition. As for Nicole Schmidt, she had limited contact with the Laundrie parents, principally in the form of a brief driveway encounter when the Laundrie parents assisted Gabby in picking up some items from her mother's home. That's from her deposition. So they're again arguing, look, these families didn't have a close relationship. They weren't spending holidays at each other's houses. Gabby's father had never met Brian's parents. Gabby's mother had met them just briefly. These families weren't close, even though that Gabby and Brian were engaged. Cross-country trip. In around June 2021, Gabby and Brian embarked on a cross-country van trip, which would involve social media postings by Gabby throughout the journey. And then it cites the depositions. A general itinerary was made known to both plaintiffs, Gabby's parents. Plaintiffs both checked in with Gabby from time to time on the van trip, typically via text and occasional phone calls. On or about August 12th, 2021, plaintiffs were contacted by Gabby about an incident that occurred in Moab. And this is from the parents' deposition. Both plaintiffs had an opportunity to speak with Gabby on that date, and at least one texted a picture of her taken at the time. And that's from their depositions. Petito advised her parents there had been an incident involving Brian, to which the Moab Police Department responded. This is new information for me. We know that there's a lawsuit ongoing, or unless it's been dismissed, but I believe there's still a lawsuit ongoing between the Petito parents and the Moab Police Department. We've seen body cam footage of this incident where they responded, and Gabby Petito, they determined to be the aggressor in that situation, though Gabby had marks on her face and was incredibly upset. So it's interesting to learn that Gabby told her parents about that incident in Moab before she was killed. Miss Petito's father was on the phone with police officers with Gabby Petito's father was on the phone with her while the officers were interviewing her and Brian, and he was acutely aware of the situation. See the Petito deposition. Interesting. The Moab Police Department suggested Miss Petito could be arrested. Instead, the Moab Police Department instructed Petito and Gabby and Brian to separate for that evening. Brian returned to Florida shortly thereafter to move some items out of storage and back into his parents' home, and that comes from the Laundrie depositions. Neither plaintiff contacted nor advised either Laundrie parent about the August 12th incident in Moab involving their daughter and Brian. On or about August 29th, Brian contacted his mother to seemingly discuss the van trip. Towards the end of the call, he sounded upset, which his mother relayed to her husband, and she recommended that he call their son. Brian's father then called him, and during the call, Brian advised that Gabby is gone and he needed a lawyer. And this is when he said he needed a lawyer. Remember, what they did then was to hire a criminal attorney in the area where Gabby was murdered. So I think there's more. Brian provided no additional details at the time, despite questioning by his father. Engagement of Mr. Bertolino. So these are the facts about Mr. Bertolino getting involved in this case. Shortly after the above discussion between the Laundrie parents and their son, the Laundrie parents reached out to their friend and former neighbor and attorney, Mr. Bertolino, to advise him of the phone call and request his counsel. Bertolino entered into an attorney-client relationship with the Laundrie parents and advised them not to discuss the matter further with Brian or to discuss the matter with anyone else. Footnote 2. The Laundrie parents voluntarily waived their attorney-client privilege so as to be as forthcoming and transparent as possible at their depositions, which still blows my mind. But I wonder if the Laundrie parents, they didn't have to. The Laundrie parents didn't have to tell anyone about any of this. They could have stuck with that's privileged and said nothing. I wonder if the Laundrie parents also believe, or their lawyers also believe, that what the Petito parents want is answers, and that at the end of the day, this case is not going to see a jury and they'll be able to resolve it. Because there's no money in the world that's going to undo the damage that's been done. If what the Petito family wants is answers, they have them now. They have answers. They have all the answers they're going to get. And if they want people to tell the Laundries they suck, I mean, I feel like that's happened. And if they need a jury to tell them that what they did was wrong, I don't know how much more that helps things. But we'll see. Bertolino then began the process of attempting to locate counsel to represent Brian and provide legal advice as may be needed. So Bertolino saying, I was not representing Brian. I was looking for counsel for Brian. Because Bertolino is in New York. The Laundries are in Florida. And all of this happened in, I don't remember which national forest it was. Not New York, not Florida. Out by Yellowstone, I think. They didn't say in any of this. So I don't remember exactly which state in the triangle of states they were in when Gabby Petito was found. Either way. On or about September 1st, Brian arrived at his parents' house in Northport, Florida, driving the van he and Miss Petito used on the cross-country trip. From that point forward, Brian provided no additional details to either Laundrie parent about what must have happened or what may have happened to Gabby. He did not further expound on the statement, Gabby is gone. Wyoming, thank you, chat. This is why I live stream. Because the chat's the best research attorneys ever. Wyoming, thank you. At the time, the Laundrie parents were continuing to follow the advice and instructions of counsel and not discuss Petito with Brian or anyone else. That's what they said in their depositions. Believe what you will. Media attention. As of September 9th, plaintiffs became extremely worried about not having heard from their daughter for a number of days. From that point until the date Miss Petito was discovered on September 19th, plaintiffs were engaged in extensive efforts to promote public awareness about Petito's disappearance and enlist assistance in locating her. And that's from all the depositions. These efforts began on September 8th, 2021, and significant public interest developed as of September 13th, 2021. Plaintiffs' efforts gained considerable traction with local, national, and worldwide media. Agreed. For example, plaintiffs were first contacted by a national media outlet interested in their story on September 12th or September 13th. This attention led to numerous local and national media interviews and statements by plaintiffs and other members of Miss Petito's family, as well as significant social media interactions involving the same, per the depositions. Per Joseph Petito, he spent virtually every waking hour attempting to promote public awareness about his daughter. And his daughter was missing. What else do you do? Like, I don't know how helpless you would feel as a parent. I don't know what else do you do? I don't know, man. This is just like parental nightmare shit. Because I'm not going to say any more about that. We're going to keep moving. We're going to keep moving. Having children is terrifying. Just I don't fault Joseph Petito at all. Of course, that's what he was doing. Plaintiffs and their respective spouses additionally retained the services of the former neighbor, friend, and attorney, Richard Stafford, to represent them and interact with the media on their behalf. Of course they did. Because they need someone to liaise all of this because they are walking through absolutely the unthinkable. Plaintiffs made one or two attempts to contact the Laundrie parents without success. And that's from the Petito Schmidt depositions. I'm surprised it was only one or two. I wonder when they were blocked. Following these efforts, plaintiffs, attorney, and law enforcement, including chief of police for Northport, Florida, engaged in a number of social media posts, press releases, media interviews, in which they brought the public's attention to the Laundrie family was not saying anything about the Petito's disappearance. But the Laundrie family wasn't saying anything about the Petito's disappearance. That is a fact. In response to the public information awareness campaign undertaken by the plaintiffs, the Laundrie parents became the subject of significant public interest, scorn, and animosity. I believe that to be true. And that's coming from the Schmidt deposition. This included a number of violent and vitriolic online posts and threats criticizing the Laundrie parents' decision to exercise their right to remain silent. Yeah, that was going on. Shouldn't have been. I mean, threats are never okay. Threats aren't all right. At all. September 14th statement. In an effort to turn down the heat, that's a direct quote. See how it's in quotations and not italices? That's a direct quote from a deposition. In an effort to turn down the heat and to protect the Laundrie parents from physical threats and being publicly coerced into making statements to law enforcement, which they were not legally obligated to make. I agree that they weren't legally obligated to make any statements. Mr. Bertolino, in his capacity as an attorney, issued a press release public statement on September 14th, 2021. The statement was provided to the Laundrie parents in draft for their review and approval, which was obtained. The statement was additionally provided to Brian's criminal defense counsel in Wyoming. Look, you are going to lose me every single time. If the Laundrie parents are trying to argue, we didn't know what Gabby is gone meant, your actions in hiring a criminal defense attorney in Wyoming tells me you knew exactly what the fuck was meant. Like, that action is not I'm worried that she's lost and we need a search and rescue party. That's That's not what they're worried about. They're not looking for search and rescue. They hired a criminal defense attorney in Wyoming. Those actions give us illumination on what they understood Gabby is gone to mean. They weren't calling the National Guard for a search and rescue, were they? They brought Brian home, or he came home. They parked the van, they took him camping, and they spent time with their son, and they hired a criminal attorney in Wyoming. Why did they go camping? I think it's reasonable to think that they believe that their son might end up, I don't know, in prison for the rest of his life. So they didn't Brian didn't call law enforcement and say, I was hiking and we were hiking and we were in this area and I need a search because my fiance is missing and this is where we were last together. No, they didn't. They didn't do any of that. They didn't do any of that. Now, I don't think the Laundries were obligated to do anything, but Brian Laundrie's behavior is telling, and the Laundries' behavior illuminates what they believed Gabby is gone to mean. They can't just argue that they believed that Gabby had broken up with Brian and, I don't know, hitchhiked to Utah or something. I don't think they can argue that, because if the two had just broken up and Gabby is gone meant Gabby dumped me, then why are you hiring a criminal defense attorney in Wyoming? You're not. So their action gives some context here to what, Emily, get it together, to what Gabby is gone meant. The statement was made to be defensive in nature, seeking to protect the Laundrie parents' personal and private interests. Yeah, it had nothing to do with the Petitos. It probably was. The statement was not directed to either plaintiff, did not refer to either plaintiff by name, and was not sent or delivered specifically to either plaintiff. Miss me. You've lost me on this argument. Here's why. You were doing it to turn down the heat on what the Petitos were saying. You knew it was going to reach them. You're now all talking to each other through the media. The September 14th statement issued by Bertolino was public in nature and was no way intended to cause emotional distress to either plaintiff. The statement in its entirety reads as follows, and we know this well because we've gone over this a million times in this case. September 14th, 2021, regarding Miss Petito. Statement from the counsel for the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That sentence is this entire lawsuit. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. If they already knew that she was dead, is that an extreme and outrageous statement that is reasonably foreseeable to cause emotional distress to the parents? On the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. At the time the September 14th statement was issued, Brian had left his parents' home without explanation. When he failed to return, the Laundrie parents became concerned. Those concerns provided valid as Brian's remains were discovered in October 2021, having taken his own life. There is no dispute that the Laundrie parents were themselves distressed at the time the September 14th statement was issued, and both were particularly vulnerable to the public acrimony and public pressure that was directed their way. And the entire situation was thrust upon them suddenly and not of their own volition, and for which they were ill prepared. Now, I know people hate how the Laundries behaved. I get it. But I do agree that there was lots of public acrimony and pressure directed their way, and that they were thrust into the spotlight very suddenly, and they were not the ones that took the actions that led them there. Their son was. Their adult son was. Response to the September 14th statement, Joseph Petito testified, this was at deposition, that upon reading the September 14th statement, he was angry because it said nothing. That is not going to be helpful for the Petito's case. Because if it quote unquote said nothing, how is it outrageous enough to be intentional infliction of emotional distress? Do you see what I'm saying? He repeatedly stated that he was frustrated that the Laundrie parents were not offering information on advice of counsel and were not helping with the search. Of course he's frustrated. They are not obligated to help. It sucks. You would think that they would want to. You would think that that would be the thing that you would do if your, future daughter-in-law was missing. One would think that that's what would happen, but they didn't. But they're not legally obligated to. Morally is a whole different question. At the same time, he admits that he expected it. At the same time, he admits that he expected it at the time the September 14th statement was issued because the messaging was consistent with the manner in which the Laundrie parents responded to law enforcement on September 11th. At no point during his deposition did Joseph Petito testify that the September 14th statement gave him false hope. Oh boy. The only time such a theory has been advanced is in Joseph Petito's answers to interrogatories, which were prepared with the assistance of counsel. However, Joseph Petito's actions immediately following the September 14th statement and his own testimony are inconsistent with a quote-unquote false hope assertion. That's going to be hard to get around if that's what's in the deposition. That's going to be hard. Nicole Schmidt, Gabby Petito's mother, testified the September 14th statement was upsetting because the Laundrie parents had more information to give and all they chose to say was what was in the statement. That is frustrating. That's very frustrating. She also testified that she was pissed off because it felt like the Laundrie parents were brushing Miss Petito off as if she never existed, which is frustrating and outrageous and upsetting. I just don't know if it's legally actionable. She similarly repeated frustration that the Laundrie parents were not volunteering information. Undoubtedly. I don't know if that frustration is enough to stand on an action for IIED. So, B2, A-Town. No, Emily, we're not singing Usher in the middle of reading this motion for summary judgment. B2, thank you for the gifted memberships. That's incredibly sweet. Thank you. I know I pulled Amy's up earlier, but I'm pulling them up again. Thank you. All right. And this is why this is such a hard case. You guys can sing in the chat. Oh, just a girl. Y'all can sing. Go get Chelsea's already on it. Get it. And this is the hard thing. Because I agree with the Petito family. How fucking livid would you be if your child is missing and the last person that saw your child alive was home with their parents, or the last person that saw your child before they were missing went home with their parents, they were engaged, and no one is saying shit? I don't know how your body encompasses that much rage. I don't know how you hold that level of rage and hurt and betrayal in your soul. I don't know. Of course they're mad. Your son's the last person that was with her. Where is she? But the Laundries have the legal right to circle the wagons and say nothing because they were trying to protect their son. And that's what they did. And there's no evidence that they lied to law enforcement, or they could have been charged for that. They aren't obligated to talk. You can't force people to speak, especially against their own potentially putative interest. But I think we all have tremendous empathy for the Petitos. And I know a lot of you who have some bigger hearts than me have empathy for the Laundries too. Because what do you do? I mean, I don't think you do what they did, but if Joseph Petito is saying that the statement never gave him false hope, I don't know how we get to intentional infliction of emotional distress. I don't know how we get there. And I want the Petitos to be made whole. I don't know how to do that. I don't know how to make the Petito family whole in this situation. So I see so many of you in the chat being like, this is so hard. It's Amanda, yes. And this is, I think, one of the reasons this civil case is so important to talk about is because there are competing rights and interests here. And it is very difficult to navigate the emotional side of this case and the legal side of this case. This one's a really hard one. Nicole Schmidt testified that the September 15th or 14th statement was upsetting because the Laundries had more information to give and all they chose to say was what was in the statement. This is again a statement that essentially their statement said nothing. And if their statement said nothing, it's not going to count as outrageous and reckless legally. But of course they were pissed off. Of course they were. Much like Joseph Petito, Nicole Schmidt never once stated that the September 14th statement gave her false hope during her deposition, and the only time such theory has been advanced on her behalf is in interrogatory answers prepared with the assistance of counsel, and that's going to be hard to overcome. However, if this gets to a jury, the emotional side might overcome quite a lot of this, because making these arguments to a judge in the gray zone of what's legal and not legal is very different than trying to argue morally reprehensible behavior to a jury, because jurors come in this like you guys do from your own life. And some people are like, I can absolutely separate the emotional and the legal and look at the legal gray zone here and be like, yeah, I hate this behavior, but I don't know if this is something you're civilly liable for. Not everyone can. And nobody wants to be the attorney in the position arguing, yeah, but they didn't really have false hope that this meant their daughter was alive. No, you don't want to make that argument. And you don't want to be the lawyer standing up trying to explain that burn after reading letter. Because what? But if they never said that that statement gave them false hope, I don't know how we get to IIED here. I just don't know if this behavior is legally redressable. I really don't. I want the Petitos to have answers, and I hope this has given them answers. I just don't know if legal liability is what they're going to get. Let's continue. But those are hard answers that they didn't get, that they did not have false hope, because you're kind of stuck with what you said at your deposition. Plaintiffs texted each other immediately after reviewing the September 14th statement and did not express hope that Petito was still alive. Instead, they discussed whether a response statement should be issued asking why the Laundrie parents were not assisting in the search. And those texts are attached as Exhibit D, which we might get to, because their texts are going to come up. As much as the Laundrie parents' behavior is going to be evaluated in this case, the behavior of the Petito family is also going to be evaluated in this case. And if that feels gross to you, that is the process of civil litigation. Everyone's behavior in this is going to be examined fulsomely, to borrow one of Rick Hoag's favorite words. Plaintiffs, through Mr. Stanford, their lawyer, did issue such a statement as follows. On what day? What day is this? Can you tell me what day it was? September 14th. Okay, so September 14th, the Petito family issued a statement. The Schmidt and Petito family are going through the worst moments of their lives. Yep. Their beautiful 22-year-old daughter is missing, and the only person that can help find Gabby refuses to help. Brian Laundrie was traveling with Gabby in Grand Teton, Yellowstone area. They were traveling together in Gabby's 2012 Ford Transit van. This is where we believe Gabby was last seen. Brian is refusing to tell Gabby's family where he last saw her. Brian is also refusing to explain why he left Gabby all alone and drove her van to Florida. These are critical questions that require immediate answers. But this statement is focused on Brian. The Schmidt and Petito family begged the Laundrie family to not remain in the background, but to help find who Brian referred to as the love of his life. How does Brian stay in the background when he is the only person who knows where Gabby is located? The Schmidt and Petito family implore Brian to come forward and at least tell us if we are looking in the right area. And that statement is focused on who? Brian. That's all focused on Brian's behavior. If they're imploring anything in this statement, they're imploring the Laundries to tell their son to help. But their son knows that Gabby is dead and is exerting his right to remain the fuck silent. That's what he's doing. He's in the I don't know what to do. I don't want to go to prison. So I'm not saying shit. The following day, the lawyer on behalf of the plaintiffs issued an open letter addressing the Laundrie parents, again imploring them to help find their daughter. That's attached as Exhibit F. It is clear that neither plaintiff accepted the Laundrie's positions that they would not be providing any information at that time. It was clear that the lawyer's September 15th statement that the plaintiffs believed the Laundrie parents knew where Brian had left Gabby. It's clear that, to me, that they were imploring the Laundries to make their son, tell us. They're imploring the parents, do the right thing. Tell him to do the right thing. The lawyer's statement was intended to ratchet up the public pressure already existing for the Laundrie parents. In addressing the reasoning behind the public statement issued on September 15th and public statements issued thereafter, the lawyer for the Petitos testified that he did not consider how the statements might impact the Laundrie parents. Right, because he was focused on his clients who were desperately trying to find their missing daughter. However, that cuts both ways, doesn't it, when it comes to IIED? If it's okay for the Petito parents to be focused on trying to get information to find Gabby Petito, and their lawyer's statement was focused not on how it would impact the Laundries, but is only thinking of the Petitos, then isn't that the same when you look at Stephen Bertolino's statement to the media, where Stephen Bertolino is saying, I wasn't thinking about how or whether this would cause distress. I wasn't trying to cause distress. I was trying to do what was right for my clients. That's going to cut both ways. Additionally, lawyer Stanford testified that he had no duty to do so, because he didn't. That his clients were the Petito Schmidt families, and it was solely their interests that he was concerned about. And isn't that the same for the Bertolinos? Mr. Stanford's statements suggest that the Laundrie parents knew the location of Miss Petito without verifying such was true, and also included imagery designed to provoke emotions. At the time lawyer Stanford issued his September 15th statement, and for a number of statements thereafter, the Laundrie parents similar to plaintiffs, did not know where their child was and whether he was safe. So this is Stephen Bertolino flipping it, saying, during this period of time, Brian Laundrie's missing. So the Laundrie family is equally vulnerable. That's their argument. Diane said it's not the same. Their son wasn't missing or dead. At this point, Brian Laundrie was missing. I think at this point he actually probably was dead, but at this point he was missing because he had left the Laundries' home and they didn't know where he was. Or they said they didn't know where he was. Because then when the water subsided and they went out to the park, they found him like immediately. I'm going to save Alco. I see your question. I'm going to save this for Q&A. So, yet they say public statements were issued against the Laundrie parents in a continual effort to keep the pressure on them to violate the advice given by their attorney to not say anything and to violate their right to remain silent in such circumstances. Yeah. These comments specifically included suggesting Brian was refusing to help or answer critical questions. I mean, he was, though, refusing to help. I mean, he had a legal right to refuse to help, but I don't think that's mischaracterizing the circumstance. They suggested Brian was refusing to help. I think that accurately summarizes the situation, or to answer critical questions, publicly proclaiming that the silence was reprehensible and tarnished Brian's love for Miss Petito, questioning how the Laundries could let the Petito family go through this pain and not help us. I'm sure that's exactly what they were feeling. And suggesting the Laundrie family had no decency left. I mean, I don't know if they suggested that or if they just fucking said that. September 19th statement. On September 19th, Miss Petito's remains were discovered in Wyoming. At the time, Bertolino issued a statement on behalf of the Laundries saying the news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. And they're like, too late. Based upon the investigation performed by the FBI, it was ultimately determined that Miss Petito likely died on August 27th or August 28th. As of the first moment that Brian advised his parents that Gabby is gone, and much later as of the first moment when the plaintiffs attempted to contact the Laundrie parents, plaintiffs' loss of their daughter could not have been prevented as it had already occurred. I mean, but did they know is more important. But no, they couldn't have prevented it. So I mean, I don't think like no harm is the right argument here. The pain that the Petito family went through in the time that they didn't know where Gabby was could have been mitigated in some way by her being found and them having answers. The pain of losing a child is not going to be mitigated, but the torment of the unknown and over 10 days of the unknown could have been. And that's going to be the Petito's argument if this goes to jury. They could have said she was last in this area and help us find her. In connection with the tragic events that resulted in Miss Petito's disappearance, he murdered her. He murdered her. In connection with the tragic events that resulted in Miss Petito's disappearance and subsequent murder, both parents acknowledged that they began experiencing severe emotional distress on or about September 9th, approximately 5 days before Bertolino's statement. And this, again, I don't want to be the lawyer in the position to argue this, but it is a legally proper argument and a strong one. And here's why. Because their argument is still going to be the distress caused is by them not knowing where their daughter is, not by anything the Laundrie said or did. Plaintiffs had no pre-existing relationship with Mr. Bertolino, and there was no reason or motive for Bertolino to have intended to inflict emotional distress upon either plaintiff. I don't disagree with that statement, y'all. I don't think Bertolino was trying to cause the Laundrie's distress. We can talk about whether or not it was reckless. I think Bertolino was acting on behalf of his client, which lawyers are obligated ethically to do vigorously. Plaintiffs suffered and continue to suffer mental anguish, pain, and suffering as the result of the death of their daughter. They're arguing that the death of Gabby Petito is what's causing the issue, not the statement. The emotional distress exists and would have existed irrespective of any statement made or not made on September 14th or September 19th by Bertolino on behalf of the Laundries. Experts. Plaintiffs have not retained any expert witness to opine that Bertolino's press releases were reckless. Bertolino has retained Wayne Pollock, Esquire, as an expert witness who has testified that the September 14th and 19th statements were reasonable under the circumstances and not reckless. We're going to get expert witnesses on like legal ethics. Plaintiff's only expert witness is Robert Gordon, who performed no testing on either plaintiff and has no objective measures of increased emotional injury. There is no dispute that plaintiff suffered a severe emotional injury and PTSD as a result of the violent murder of their daughter. Indeed, plaintiffs have both appropriately sought counseling for this very reason. Sometimes being the lawyer is hard. I imagine trying to argue that the injury came from the fact that she was murdered and missing and not from the statements is a hard position to be in. I don't think they're wrong to argue it. It's just not, I wouldn't want to do it. Civil litigation is not civil. It often feels really awful. Testifying that she started counseling to help deal with the issues involving Gabby's disappearance and death. Of course her mother did. And then the Petito deposition testifying the murder of Miss Petito was the reason why his wife encouraged him to seek treatment, as he should. But they're again going to argue they were in treatment. They were seeking counseling and support because their daughter was brutally murdered. And not because of the statements made. Emily Rose asked in the chat, wait, are we weaponizing seeking support? Okay, so in the civil litigation, they have to, Bertolino and the Laundries have to distance themselves and the statements from causing the harm. And so what they're saying is that the Petito family were rightfully seeking treatment and help for the severe emotional distress they were going through. But the severe emotional distress they were going through was caused by the fact that their daughter was murdered and was missing, not based on the statement. So no, they're not weaponizing it. They're litigating the facts of the statements aren't what caused the emotional distress. The underlying facts are. They're trying to distinguish between the two. I can absolutely understand why it feels that way. Civil litigation is brutal. It's absolutely brutal, which is why a lot of people choose not to go through it. Because everything that the Petito family does is going to be used to point out that it's not legally the Laundrie's fault. So that's what that is. Standard for review. Florida has adopted, hopefully that makes sense. I know it feels awful. Aaron, was I word salading? I hope I wasn't. I hope I wasn't word salading. I was trying to explain. Florida has adopted the federal summary judgment standard articulated in case law. Under this standard, a party against whom a claim is asserted may move for summary judgment in the party's favor as to all or any part thereof. With or without supporting affidavits, the judgment sought must be rendered immediately if the pleadings and summary judgment evidence on file show there is no genuine dispute as to any material fact. And that's what we're here for. Is there a genuine dispute of material fact? Are there any facts that go like, could be this, could be that the jury has to decide? And that's where we're at. I don't disagree with their statement of like the standard argument. In this case, the record evidence fails to support each of the essential elements of the IIED claim against lawyer Bertolino. The statements at issues were not made with the intent to harm the plaintiffs, but instead were issued to the public generally after careful consideration and following specific prompting from the public and the plaintiffs. The statements were not outrageous, but instead were defensive statements designed to express the sincere wishes of the Laundrie parents. The statements did not cause plaintiffs severe emotional distress. The loss of their daughter did. It's a very large truck. Perhaps more importantly, because the statements concern a public issue, they're protected by the First Amendment. Applicable law. As to count 3, Petito. So remember, Bertolino is being sued by Gabby Petito's dad and Gabby Petito's mom. So there's one count for each plaintiff, like each plaintiff against each defendant. Thanks, Aaron. I'm trying real hard. I appreciate Aaron clarifying that the word salad was not me. It's so hard. Thank you, Aaron. It's hard to parse. And it's also hard, like lawyers can really default into no emotion zone, and that feels real yucky too. So it's hard to compassionately explain the legal gray zone when the emotion needs to come out of it, if that makes sense. In count 3, Joseph Petito asserts a claim for IIED against Bertolino. In count 6, Gabby's mother, Nicole Schmidt, does the same. Both counts are once again premised on both statements. To prevail on a claim for IIED, plaintiffs must present evidence demonstrating the 4 elements: deliberate or reckless infliction of mental suffering, outrageous conduct. The conduct caused the emotional distress. The distress was severe. Look, this is where they're trying to parse the causation. That's this third element here. Did the statements cause the emotional distress? Or was the emotional distress already existing, irrelevant of the statements or irregardless of the statements? Was the statement deliberate or reckless infliction of mental suffering? I still think that is a question for a jury. I don't know how you get to that not being a question for a jury, because you're trying to ascribe motive. And how do you describe how does a court determine as a matter of course that it's not deliberate or reckless? Isn't that always just a jury question? Outrageous conduct. Is the conduct outrageous? Does it feel outrageous to you? Is the word reunited assuming, arguendo, if you assume that the Laundries knew that Gabby Petito was dead, is the statement that their lawyer issued outrageous? And is a determination of what is and is not outrageous in a civilized society a determination for a jury to make, not for a judge to make? Isn't what is outrageous always going to be a factual determination by a jury? Right? So I think those two, I think on 1 and 2, those feel, this is emotional. These feel like jury questions for me, because isn't this exactly what a jury's for? And then the conduct causing emotional distress is going to get parsed down, and the distress was severe. I think it's going to be icky for them to argue the distress wasn't severe. They're going to argue the severe distress was over something else. The behavior forming the basis for such a claim must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. Would you expect, and we're going to switch brains, y'all, come along with me on the intellectual exploration. We're having law school today. Would a family in the shoes of the Laundries, We're going to have to put ourselves in the Laundrie shoes. I know you don't want to. We're going to have to do it for a minute. It's going to feel weird. Just come with me. In the shoes of the Laundrie family, given this situation, would one expect them to make some sort of a statement to the media after statements were being made about them or calling them out, after people were standing outside their house? Would you expect them to make a statement? And if you would expect them to make some type of statement, was their statement neutral enough to not be so outrageous in character and so extreme as to go beyond all possible bounds of decency? Is it icky? Yes. Does it go beyond all possible bounds of decency? And isn't that a question for a jury? Or would you expect a family in their situation to make that statement? And when you have the statements by the Petito family saying, we were frustrated because their statement essentially said nothing. A statement that says nothing, a general like thoughts and prayers statement, is a statement that says nothing, a statement that goes beyond all possible bounds of decency. Did it mislead them? Did it delay things? Or was it just the most watered down boilerplate thoughts and prayers? But then again, isn't that for a jury in Florida to decide? Isn't it for the residents of the state of Florida to decide what they consider to be so outrageous and so extreme in degree that it goes beyond all possible bounds of decency? Isn't that for them to determine? I know. And I see Candy Curls in the chat, the curls are giving everything, said that gave them false hope. I agree that that's what the lawyers have argued. But that's not what the Petito family said in the deposition. What the Petito family said in their depositions, according to this motion, and there might be more context, and there might be more context to it. But what they're arguing here is what the Petito said in the deposition is that they were mad that the statement was essentially giving them nothing. Not that it gave them false hope, that it gave them nothing. Which is hard. So they say in applying that standard, the subjective reason of the person who is the target of the actor's conduct does not control the question of whether or not the tort of IIED occurred. I think outrageous conduct is a jury question. The standard for outrageous conduct is particularly high in Florida. What are they saying? Florida has a high tolerance for bullshit and weird shit? Florida's like, get out of your feelings. Florida's just like, get out of. There's a lot that's going to fly in Florida. So to get to Florida outrageous, it's going to have to be real fucking weird. Is that what the law is saying in Florida? Sorry, Florida. I don't mean to take shots at your state for the levity of all of us, but I mean, they're like, look, we expect you to have a thick skin here in Florida. The standard for outrageous conduct is particularly high in Florida. I wanted to just say, comma, because Florida. It is not enough that the defendant acted with an intent that is tortious or even criminal, or that the defendant intended to inflict emotional distress, or that the defendant's conduct can be characterized by malice or a degree of aggravation, which would entitle plaintiff to punitive damages for another tort. Like, it has to be real fucking bad. They say that the September 14th statement is not actionable, that Bertolino's conduct was not intentional or reckless. Mr. Bertolino and the Laundrie parents were extremely sympathetic to plaintiffs and the plight they faced. Katie S. said, is Florida man a defense? I mean, that's kind of what they're arguing. They're arguing, look, what might be outrageous for y'all in some other state is not going to be outrageous in Florida. Like, the level of outrageousness in Florida is gotta be real high. Real high. Like, it's gotta be real bad. And a neutral they're going to argue a neutral thoughts and prayers type of statement is not going to meet that very high bar. And they're trying to argue that that's a determination as a matter of law, not fact. Like, what's outrageous is not a factual determination for a jury. Because if what's outrageous is a factual determination by a jury, then there's no way you get summary judgment on this, right? Bertolino and the Laundrie parents were extremely sympathetic to plaintiffs in the plight they faced. Upon advice of counsel, the Laundrie's parents themselves declined to make any private or public statements regarding the disappearance or status of Gabby Petito, a decision that was not targeted towards plaintiff, but rather was designed to ensure that the Laundrie parents' rights were properly protected. Yeah, I do believe that. I absolutely believe that the first consideration for the Laundries was not themselves ending up getting arrested for obstruction in any way or any aiding and abetting after the fact. That once it was like, I need a lawyer, Gabby's gone, that they went into full like circle the wagons mode, because then they were like, what do we do now? I don't doubt that. As a byproduct of that lawful and legal justified decision to remain silent, I don't disagree, but they didn't remain silent. They didn't remain silent. Plaintiffs' family, law enforcement, and others use social media, mainstream media, and other public means to exert pressure on the Laundrie parents to speak to the issue of Miss Petito's disappearance, despite their right not to do so, as is their right. You can remain silent, and they can be like, why the fuck aren't you helping us find Gabby? Footnote 3. Plaintiff's desire to obtain information is certainly understandable, as was their request for the Laundrie parents, in particular, to disclose what they knew. Equally understandable was the Laundrie parents' right not to do so. I will just interject right here that I think that these defense attorneys, and I would love to know your thoughts in the chat, I think that these defense attorneys have done a good job of making difficult arguments in a sensitive way and acknowledging the hurt, the pain, the anger, and the suffering of the Petitos, while still making the legally appropriate arguments for the Laundries. I think they've threaded this needle fairly well, considering it is a very difficult needle to thread. And I appreciate that. They go on to say, apart from online vitriol directed towards the Laundries, there were tangible efforts in the form of protesters standing in front of the Laundries' home with signs and bullhorns demanding answers. Yeah, I thought that was extreme. I don't know how you guys feel about it. My personal opinion, I can't imagine, unless you're actually the Petitos and the friends of Gabby Petito, I can't imagine people just standing outside the Laundrie home with bullhorns screaming at them and thinking that that's going to help, because it doesn't. I think that oftentimes people don't know where to put their emotions and don't know what to do with them. But that was appalling to me as well. I didn't like it at all. Also, it's going to make people double down. It's not going to make them say anything. It makes everybody, the problem is that makes everyone double down, right? Death threats against the Laundries just make them double down. It's not going to make them come forward with information. So, and I understand people have a right to free speech. They can stand in a public street and yell shit. I get it. I just, I don't know. Against that backdrop, Mr. Bertolino consulted with his clients, the Laundrie parents, regarding the situation, and the collective defendants agreed to issue a public statement. The statement was an exercise of all defendants' legal right to speak and was done in a legally permissible way. The statement was carefully drafted and was reviewed and approved by the Laundrie parents. NIT 1 Law 2, is this, wait, where'd it go? Is this in Florida State Court? Yes. In front of, or at least it was in front of, and we'll see if it is still in front of, the judge who did the Maya trial. Additionally, Mr. Bertolino took the extra precaution of providing the statement to Brian's attorneys in Wyoming for their review and input. I mean, that wasn't done to protect the feelings of the Petitos. That was done to protect the criminal rights of the Laundries and Brian Laundrie. On September 14th, the statement was issued to the public in the form of a press release. It did not reference either plaintiff by name. It was not made or addressed to either plaintiff. Okay. We've heard these arguments again and again and again. Let's see if there's anything else. Bertolino's conduct was not outrageous. Whether conduct is so outrageous in character and so extreme to degree as to go beyond all possible bounds of decency is a question of law. This is what I just said. Will these statements as a matter of law be deemed out the type of statement that can be sued for here? This is going to be a difficult question for this judge. This is true because the subjective response of a person affected by the conduct does not control. Like, whether or not the statement hurt somebody's feelings is not the standard here. Rather, the conduct must be evaluated objectively to determine whether it is atrocious. Why can't I say that? Whether it is atrocious and utterly intolerable in a civilized community. And again, I don't take anything away from the pain that the Petitos were in. I don't think anything does or can. I don't know if "we hope the search is successful" statement is utterly intolerable in a civilized community. This court has already found that as a matter of law, the September 14th and September 19th statements on the surface did not constitute outrageous conduct or intentional infliction of emotional distress. But then why is this case still going? See order denying defendant's motion to dismiss. To circumvent this ruling, plaintiffs have attempted to establish that while the statements may otherwise have not been actionable, the statements somehow rise to the level of outrageous based on a purported knowledge of the Laundrie parents as well as Bertolino of facts pertaining to Petito's death and location of her body. However, the only competent record evidence addressing such purported knowledge of the Laundrie parents and Bertolino unequivocally shows that the collective defendants had no such knowledge. When Brian Laundrie said, and this would be my argument if I'm the Petitos, this case is a case that I think will be studied in law school, or should be, because it's a difficult discussion and worthy of lots of discussion, of like intellectual legal exploration. Does it change for you the statement if you know that the statement is made at a time when Bertolino and the Laundries know that Gabby Petito is dead? Does that change the statement? And does that change the statement? Lyndon clocked the issue immediately and said, there it is. Did the motion for summary judgment just introduce a fact in dispute? Yeah, that fact is in dispute. And I think the chat agrees that it changes it. Knowing if they knew that she was dead, does it change the nature of the statement? And is that the fact in dispute? Is the fact left in dispute whether or not the Laundries and Bertolino knew that Gabby Petito was dead when the statement was made? And if so, then that is the fact in dispute. The fact in dispute is, did the Laundries know at the time the statement was made that Gabby Petito was dead? And their behavior, Mr. Bertolino, they say that the record evidence shows that the Laundries and Bertolino had no such knowledge. I disagree. I think that's in dispute. Why? Because if you don't believe that Gabby Petito is dead, why are you hiring a criminal defense attorney in Wyoming when Gabby is gone? Why aren't you looking for a search party? I think that is a fact in dispute. That fact, did they know? And then the burn after reading letter is also a fact in dispute. Notice they don't mention it. They don't mention it at all. The date of the burn after reading letter is in dispute. So those are two things in dispute. When was the burn after reading letter written? And that goes to the knowledge of Roberta Laundrie. And did they know that Gabby Petito was dead when the statement was made? Specifically, the Laundrie parents both testified under oath that they did not know their son murdered Miss Petito or that she was dead. While Brian told his parents Gabby's gone, Brian offered no other details. They hired a criminal defense attorney, not asking for search and rescue. My argument. And the Laundrie parents did not believe gone could only mean that she was dead or that their son murdered her. The Laundrie parents understood something was wrong. He showed up with her van without her, based on their discussions with their son, and considered all possibilities, including the possibility that she was murdered. However, the record evidence establishes they absolutely did not know with any degree of certainty that Petito was deceased at the time the statement was made. I think that's a fact in dispute. Similarly, while Bertolino considered all scenarios, including the possibility that Petito might be dead, there's no record evidence to show with any degree of certainty that he knew she was, in fact, deceased at the time the statement was issued. That's the fact in dispute. Lyndon was like, that's the fact in dispute. When he said gone, they all asked as if he was, Brian Laundrie told them that Gabby Petito was gone. And they all acted like they had a Fifth Amendment right to remain silent because they were worried about criminal liability. I think a jury can determine that their behavior indicates that they knew there was potential criminal liability there. And there wouldn't be potential criminal liability there if she had just broken up with him, right? However, even if the plaintiffs could somehow show that the collective defendants definitively knew, I think that's a jury question, that Petito was deceased as of September 14th, the statements still do not rise to a particularly high standard of outrageous conduct in Florida. Because Florida. I'm going to add that to every sentence. It's not in here. Law nerds just know that every time I say because Florida, it's not actually in here. That's me. As explained in the expert report prepared by Wayne Pollock, a reasonable attorney in Bertolino's shoes who, for the sake of argument, knew what happened to Miss Petito could not disclose information protected by attorney-client privilege, agreed, and or information that would negatively impact his client's position, and knew a public statement was necessary to minimize negative publicity and public sentiment about his clients, would carefully craft a statement like the one issued by Bertolino that neither confirmed nor denies what happened to Gabby Petito. I agree with that. And I think that's a big hurdle to overcome at trial. I just think at trial, the emotion might overcome some of this. The statement was necessarily ambiguous and vaguely phrased to apply to multiple scenarios. For this additional reason, plaintiffs have not and cannot demonstrate an essential element of plaintiff's claim, outrageousness. No, we're not singing Britney. You guys can in the chat. And summary judgment in favor of Bertolino is due to be granted. Then they're going to argue causation. The argument we've seen made multiple times. The Petitos were already distressed. The statement did not cause distress or additional distress. I actually do. Emily, were you going to skip this? Yes, but now I want to see what's said at the depositions. It's undisputed that plaintiffs were already in a state of extreme emotional distress at the time the September 14th statement was issued by Bertolino on behalf of the Laundries. For example, Nicole Schmidt, Gabby Petito's mother, states that as of September 13th, she was in a state of shock that is indescribable. I don't doubt that at all. As the search was ongoing for her daughter, and she confirms her anxiety and pain were immeasurable at that time. Joseph Petito similarly admits that he was experiencing emotional distress as of September 13th. Plaintiff's emotional distress as they search for their daughter is understandable, justifiable, and warranted. These lawyers truly have done a very good job with this. But they're again separating the distress. They're distressed because of the ongoing situation, not the statement. And that the issue of the cause is a problem. And if we get to if we get to one element that as a matter of law my brain just stopped. If we have one element of IIED that as a matter of law cannot be proven to a jury because there is no factual dispute, it's going to kick this out as to Bertolino, and causation might be the thing. Akumiko Cross said, just because someone's already upset, distressed, doesn't mean your statements, actions can't make it worse, but they have to prove that it did, is the thing. And I don't know if they're going to be able to prove that the cause of the severe emotional distress is the statement. I don't know if they're going to be able to prove that. According to plaintiffs, this is the Petito's statements and depositions, the 14th statement frustrated them and also gave them false hope that it was possible to find their daughter. As a starting point, there are no reported cases within the state of Florida which establish that false hope can be a basis for IIED. Nonetheless, to the extent plaintiffs intend to maintain some type of false hope theory, further examination and discussion of the concept is warranted. Like, is that even legally valid? False hope is hope that is unwarranted or unfounded as becomes known in retrospect. Odd way to phrase that. Prospectively, false hope is no different than, quote, hope, which is generally considered a positive emotion and antithetical to claims of emotional distress. Interesting argument. To the extent that September 14th statement gave plaintiffs any hope, such would have reduced their emotional distress prospectively because they would have had some increased reason to believe their daughter was still alive. Again, that was not the intent of the statement. However, even if they did receive hope from it, such an emotional response would not be actionable. The next issue is the effect of the September 14th statements in terms of false hope at the time that Petito's death was confirmed on September 19th. At the time, plaintiffs certainly suffered and continue to suffer severe emotional distress due to the violent death of their daughter. Under a false hope theory, plaintiffs would have had to reflect back on the September 14th statement to determine that the positive effect they received from it, hope, was not warranted. Plaintiffs would then be asserting some type of exasperation of the emotional distress already experienced as a result of the death of their daughter, based on the now understood concept that perceives hope from 5 days prior was falsely created. There is no cause of action under Florida law for retrospective intentional infliction of emotional distress based upon newly discovered information. It's a really interesting parsing of, well, you can't say it's false hope in the moment, because in the moment you don't know it's false. If it's hope, it's hope. Interesting. They go and say, indeed, plaintiffs' respective mental health counselors have confirmed that plaintiffs receive counseling services to process the traumatic psychological effects of losing their daughter to homicide. Again, they're arguing not the statements. Even if false hope was actionable, the record evidence does not support plaintiffs' claim that they actually had hope as a result of the September 14th statement. The record evidence shows plaintiffs were becoming more desperate each day, were going through the worst moments of their lives in the 24-hour period immediately following the issuance of the statement. Additionally, after the statement was issued, plaintiffs implored the Laundrie parents to disclose the location of where Brian left Gabby, and further stated publicly that the Laundries know where their daughter is. And if Brian had disclosed where he left Gabby, he would have been arrested, likely imminently. Nicole Schmidt also explained that immediately after reading the statement, she was still looking for information to confirm whether her daughter was alive. Importantly, neither plaintiff texted or otherwise communicated to anyone that they believed their daughter was still alive, or that they were relieved or comforted by the sentiments expressed in the September 14th statement upon reading same. Plaintiffs have no positive reaction to the September 14th statement whatsoever, which is completely discordant with the allegations that it made them more hopeful. Footnote 4. Plaintiffs repeatedly stated that they never lost hope prior to the confirmation of Miss Petito's death. Thus, even the concept of false hope is one of degree, which is immeasurable. We are now parsing hope. These lawyers are in the very difficult position of having to parse whether hope can be the basis for intentional infliction of emotional distress. Because the argument here is that you can't give someone false hope in the moment. The false hope has to be retrospective because you have to have the other thing happen, discovering that she's dead, to then look back and be like, but you made me think that she was alive and that hope was false. It's a very interesting argument. Not an argument I would want to have to make. I think they're making it well. But they're making it that false hope can't be the basis of this claim. It's undisputed that plaintiffs believe any statement made by the Laundrie parents through Bertolino, which did not disclose the full and complete knowledge, would have upset and or annoyed plaintiffs because it would not have forced their son Brian to accept responsibility. Thus, it cannot be said that this statement, as opposed to any other benign statement which did not disclose information, is what proximately caused plaintiffs to experience severe emotional distress. Again, the statement wasn't the distress, is their argument. Sufficient quality of emotional distress caused by the statement has not been established. To prove a claim for IIED, the plaintiff's evidence must sufficiently establish that both the existence of emotional distress and the quality of the emotional distress, such that a fact finder may reasonably infer both that the distress did in fact happen and the quality of the distress was too much for a reasonable person to be expected to bear. And this is where they're going to keep parsing the causation that the distress that the Petitos were in was due to the circumstances, not the statement. And they're going to continue to argue that. They talk about the September 19th statement, which I'm not going to get into because we've argued it. They argue that the First Amendment bars the claim that this is speech on a public issue, and therefore cannot serve as the IIED basis. Let's see. Deciding whether speech is of public or private concern requires the court to examine the content, form, and context of the speech as revealed by the whole record. The court is obligated to make an independent examination of the whole record in order to make sure the judgment does not constitute a forbidden intrusion onto the field of free expression. They go through quite a lot of case law on that. Let's see. The litigation immunity is real difficult because I don't think this was in the course of judicial proceedings, right? The litigation privilege, quote, extends to the protection of judges, parties, counsel, and witnesses, and arises immediately upon the doing of any act required or permitted by law in due course of judicial proceedings or as necessarily preliminary thereto. So they're going to argue that these, Emily, just keep reading. These statements are necessary preliminary to judicial proceedings. And these are pre-suit communications. They didn't know a lawsuit was coming. This argument, I think, is the last argument because it is the weakest argument. It is not well taken by me. Public policy. When angry protesters are outside an individual's home, when threats of death and violence are made, when the national and world news media sends multiple requests for information on an hourly basis, and when a sympathetic young girl is missing and presumed dead, and these forces come together to singularly focus and put pressure on one family, the Laundries, an extrajudicial response is not optional, it is necessary. At a minimum, an extrajudicial response, an extrajudicial response in the form of a public statement is certainly within the family's legal right. The equation cannot be in the instant circumstance that plaintiff and their attorney, Stanford, had the right and ability to make any statement they wanted about the Laundrie family, what the Laundrie family parents purportedly knew, and what their alleged motivations and intentions were without the Laundrie family having their own right to respond. The barometer for that response cannot be, will it upset the plaintiffs? The barometer of the response must be what is in the best interest of the Laundrie parents in terms of making the public sentiment given the circumstances beyond their control. Oh, public statement, sorry. With respect to Mr. Bertolino, he's an attorney He, as an attorney, needs to be able to make a statement without fear of being personally sued by the other side who created the need for a public response in the first place. Oof. Um, it's a rough argument to make in this circumstance, but also lawyers need to be able to vigorously defend their clients. That's their job. And do I personally think that Mr. Bertolino went outside the bounds of his duty to his clients? No. Isn't that what you want the lawyer to say? Hey, we also hope they're found. And I think we could see different results again. I think we could see different results as to Bertolino versus the Laundries. But it's a hard argument to make. But they're saying we were forced to respond by the things that were being said by the Petitos, who were absolutely beside themselves searching for their daughter. It is self-evident that the September 14th statement was defensive in nature. It was created to explain why no further information would be coming from the Laundrie parents and to acknowledge that the entire situation was difficult for both families. Plaintiffs seemed to be outraged that the Laundrie parents found the situation difficult themselves. It is true that we live in a society that has very little sympathy or understanding for parents of a child who is accused of and or commits a violent crime. The question becomes, however, does that family who receives no benefit of the doubt, who receives no sympathy, and who is the focus of anger and animosity lose the right to defend themselves against an onslaught of public opinion? Unless the answer to that question is yes, then such a family must be able to hire an attorney like Bertolino, who must be able to make a public statement without fear of being sued by the other side. Public policy favors the lawyer's ability to speak for their client without fear of legal reprisal. I agree with that part. Conclusion. There is no reported case or interpretation of the restatement of torts which supports the proposition that the type of public statement issued by Bertolino on behalf of his clients in the context in which those statements were issued and the manner in which they were published, and given the nature of the wording used, is actionable or meets the elements of IIED. I think that the case against Bertolino is very difficult. I think that his statement was within the bounds of making a statement on behalf of his client. I think it's tough. Defendant Bertolino's motion for summary judgment, Exhibit A. This is the statement that was sent to the attorneys. This is the statement the attorney sent to the Laundries to approve. Emily Zelko in the chat said, hey, torts is a law class. First time I've heard it outside of the class title. Yes, torts, we're in torts today. We're dealing with intentional torts. We're dealing with this is a very difficult, legally difficult case. The facts are difficult and horrific and sad. The law doesn't well redress this kind of wrong. And then you've got Bertolino, the lawyer, in it, who has the right to make a statement on behalf of his clients. And is that statement so outrageous? That statement is not coming out against the Petitos. It's not attacking the Petitos. It's saying this is hard for everybody. Thoughts and prayers. That's hard. Because you would hope, if you were ever in this situation, and I hope none of you ever are, that the other family would help you find your kid. You would think that would be the decent thing to do. That doesn't mean it's legally actionable, and that's what's so hard here. Mariko asked, wasn't Bertolino acting as a family friend and spokesperson, as I do not believe he was able to practice in Florida? He was acting as their lawyer. He was not appearing in court, and you can hire attorneys in different states from where you are. So all the evidence in this case is that he was acting as their lawyer. So Natasha said, I'll never defend it. I get it. I get it. Exhibit B. This is the motion for summary judgment. Redacted. Defendant Bertolino's motion for summary judgment. Redacted. Those are the answers. I wanted to see the text messages. Hold on. Let's see what's not redacted. Emily, back up. Stop getting crazy. Plaintiff Joseph Petito's supplemental answers to defendant Stephen Bertolino's set of interrogatories. Please provide the name and address of the person answering these interrogatories. Petito with Pat Riley, lawyer. Were you experiencing emotional distress relating to the disappearance and well-being of Gabby Petito on September 13th? If yes, describe. Yes. Yes. Answer, yes. It gave us false hope. They let us on that it was possible that we could find her alive. Not that they wanted to help, though. They wanted to stay in the background. That's the answer there. Let's see what the answer is. This is going to be Gabby Petito's mom's answer. This is being answered with lawyers. Were you experiencing emotional distress on September 13th? Yes, I was in a state of shock that is indescribable. Yeah. I do not wish this on any parent. I wasn't eating, sleeping, or able to stop shaking for months. I was scared for my safety. I put up cameras on my home. My anxiety and pain were immeasurable. How can this even be a question? Pure evil to ask. And this is why this case is going to be hard. Because the legal case is not clear. The emotional case is very clear, right? If you have Gabby Petito's parents testifying, you're going to feel the pain and distress they were in. And then a jury's going to be asked to parse that pain and distress. And it's going to be argued to a jury that that pain and distress is because their daughter was dead and missing, not because of the statements made. And they're going to have to try to parse that. And that's hard. Did the statement cause emotional distress at the time you first learned, heard, or read it? Please describe. Giving false hope to a family desperately searching for their missing child is evil, vindictive, and inhumane. The statement was condescending, deceptive, and revolting. Oh, plain revolting. It made me feel like these people have no soul or morals. It felt like we were being kicked while we were already beaten down. Made me sick. And I agree with all of that, right? I don't disagree. That's how she experienced it. But does that go, again, does that go to Bertolino or does that go to the Laundries, right? Exhibit D, Bertolino's motion for summary judgment. These are text messages between, I think these are the text messages between the Petitos. Lawyer's statement. Would you like to issue a response statement to their statement? I would like to say something along the lines of, if you understand they're searching, then why aren't you helping? Sorry about that. Didn't mean to say that in the group chat. That's definitely your cousin. Stephen Bertolino's motion. Let's see. Exhibit E. This is the statement made by the Petito family. This is a letter from the Petitos to the Laundries. I haven't seen this before, so we're going to go over this real quick. This is from September 15th, 2021. Christopher and Roberta Laundrie, we are writing this letter to ask you to help find our beautiful daughter. We understand you are going through a difficult time and your instinct is to protect your son is strong. Oh, this was released publicly. Okay, so this was sent to them as a letter and released publicly. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. We believe you know the location where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how could you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family has any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. All we want is Gabby to come home. Please help us make this happen. And this is the day after the statement that's being argued to be actionable from the 14th. Let's see. These are media articles. And that's it. That's the end of the motion for summary judgment. And that is a full 2 hours. We're going to take a look real quick at the other motion for summary judgment. We're not going to go through the entire thing. It's going to be very, very similar. But we're going to go through a little bit of it real quick because I said we were going to go through it. And then we're going to get to Q&A because you guys have a lot of questions. Let's see. Let me make this a little bit bigger. And we'll go through some of this. And then if you guys want me to go through some of the depositions, we can. I think what I might do is wait for the response. The Petito family is going to respond to both of these. Wait for the responses and then go through the responses because we're going to see more information from the depositions then. And just wait till they respond. If and when these are argued, they will be argued in open court. I will be covering that for sure. This is going to be difficult oral argument, but these are very, very important motions because Stephen Bertolino could get removed from this case on summary judgment and it could just go to trial against the Laundries, or it could all get kicked. Like this could happen. Zebra Strong in the chat said, got a job interview. Wish me luck. Good luck. Hopefully the chat will wish you good luck. So I might just wait for the response and then go through that because the response will point out other things from the depositions as well. And we've got a trial starting next week with Rust. So we might just not have time. Introduction. This is a cause of action based on the alleged IIED. The alleged wrongful conduct is speech concerning a public issue, more particularly press release issued by defendant Stephen Bertolino. This is the exact same opening. Exactly the same. I imagine this is almost exactly the same. The statements at issue were defensive in nature issued publicly for the purpose of responding to significant public pressure. Let's see. Undisputed material facts are the same. Cross-country trip, same. Engagement of Mr. Bertolino is the same. Media attention is the same. This is, I imagine this is going to be the exact same motion, except for, let's say, standard of review is the same. Applicable law is the same. Mr. Bertolino and the Laundrie parents were extremely sympathetic to the plaintiffs and the plight they faced. Upon the advice of counsel, they declined to make any private or public statements. This is going to be the exact same, except for the litigation privilege, maybe. But even then, it would carry on to them potentially making a statement. The Laundrie parents' conduct was not outrageous. Where's their argument on that? The Laundrie parents both testified under oath that as of September 14th, they did not know their son murdered Ms. Petito or that she was dead. Well, Brian told his parents Gabby is gone. Brian offered no other details. The parents did not believe gone could only mean she was dead or that their son murdered her. All right, let's see if there's anything else in this, because this is essentially the exact same motion. And we'll get to questions then. The First Amendment bars plaintiff's claims, which is going to be a real interesting argument. Let's see. This is almost the exact same length as the other one as well. This is the argument for litigation privilege. Let's see. Public policy argument, conclusion. Yeah, this is the same exhibitors, same arguments. All right. So, yay. The two motions for summary judgment are the same. Let's do a quick recap here. This is not an easy case. This is not an easy case. This is an incredibly sad case. And I think as empathetic humans, we are very empathetic to the pain that the Petito family was in. And I think a lot of people are empathetic to the situation that the Laundrie family was in, right? It's what do you do? And if you do nothing, you're kind of screwed. Uh and if you say anything, are you going to get sued? And do these types of lawsuits make it more likely that people in the future will just not say shit? This lawsuit would not exist had there been no statements. You can't sue people for failing to speak. The Laundries didn't have to tell law enforcement anything. They can't lie, but they didn't have to tell law enforcement anything. They didn't have to tell the Petitos anything. Legally, morally, I wish we lived in a society where, this wasn't happening. But when you get to trying to legislate morality, we've got a lot bigger problems on determining whose morality is the one that we are legislating. And that becomes a whole big public policy conversation of how do you legislate morality? Or do you try to create an environment where people can do the right thing without being legally held responsible for it? I don't think the Laundries, before Brian went missing and took his own life, I don't know if there's much they could have said with their lawyer telling them anything. They were in a tremendously difficult position. The Petitos were in an impossible position of grief and horror and fear. What the Laundries knew and when is going to factor into this, and I think that might be the question that ends up turning this motion for summary judgment as it comes to the Petitos. But even if there's a question as to what the Laundries, as to what the Laundries knew when they made the September 14th statement, I don't know if that's going to get them past the motion for summary judgment, because the issue of causation is a big problem in this case. This is not a legally simple case. This is not this maybe should just go to the jury. This is not an easy one. And no matter what happens, it's going to be appealed, and we're going to keep a look at it, because it's a tough one. It's a really tough one. And the Petitos have the uphill battle on this case until they get to a jury. I think once you get to a jury, you have an emotional component of a jury, and the emotional component of not just reading the pain of the Petitos, but a jury seeing it and separating that pain from whether or not the Laundries are the ones that cause that pain can be difficult. Though I do believe juries take their duty seriously. And I do think this could be a case where a jury says, "We are so sorry for what happened to you. None of this should have happened. You lost your daughter in a unimaginable way. And that's Brian Laundrie's fault. And that is not Stephen Bertolino's fault. And that is not the Laundrie's fault. And we don't know if they made that worse by making a statement in the media saying they're not going to make any further statements. We don't know if that made it worse, because what can't be actionable is them saying nothing. So the Petito's lawyers can't argue at trial, they should have told us where Gabby was. That's not actionable. Let's get to your questions. You have a ton of them, and I understand why. Because we want someone to be responsible. And in this case, the person that's responsible ultimately is Brian Laundrie, and he is deceased and can't be held responsible any further. He was charged with using her credit cards. He was never charged with murder, because by the time that was all determined and he was found, he was dead. So there's nowhere to put the emotions of this case. There's nowhere to rectify it, make it right. It feels like there's no justice because there's no formal process for holding anyone responsible, and it leaves everyone just hanging, right? And that makes this incredibly difficult as a case. And I absolutely don't fault the Petitos for bringing this lawsuit at all. I don't. They wanted answers. Of course they did. I think they're entitled to that. I hope that they've gotten them. I don't know if those answers will bring them any respite, though, because as part of those answers, what they've gotten is that Brian told his parents Gabby's gone, came home with her van after using her debit card. The van was parked. They all went camping together and got to spend time as a family, knowing that this horrible thing has happened. And they got to say goodbye to their son. And the Petitos never did. And I don't think this lawsuit's going to right that wrong for the Petitos. I don't know if anything takes that pain away. And I don't know if this is what IIED was intended for. I don't know if these comments by the lawyer, given the circumstances, are comments of the type of outrageousness that are legally actionable. I truly do not know. So, with all of that, you guys have a lot of questions. The behavior of the Laundries was not great. Just don't know if they're going to be civilly liable for it. And I struggle with that because you want people to have a path to heal and be made whole. And there's not really a path forward in this case. It's all just so sad. So we're going to get to questions. Tara, I'm going to come to your question first because it's a good question and I have an answer that's easy. And I need something to be easy in this case because nothing is easy in this case. It's horribly sad. And this case, I think, exemplifies where there are very difficult cases to be an attorney. And I think these attorneys, we've seen some attorneys act awfully when we don't like their client, right? It's like, I don't like your client. I don't like your client's case. And I definitely don't like how you're acting. I think these lawyers have done a real good job of making difficult arguments in a sensitive situation while continuing to be sensitive to the fact that, of course, the Petito family are in pain and they're also trying to thread the needle. I have a tremendous amount of respect for the defense attorneys in this case who are doing a good job with a difficult case. So if this goes to trial, I expect it will be very emotional, but we'll see some really good lawyering. Just such a heartbreaking and sad case. Tara said, could they sue for wrongful death? The Petito family cannot sue the Laundrie family for wrongful death. The estate of Gabby Petito already sued Brian Laundrie for wrongful death, and that lawsuit was resolved with a judgment. I believe the judgment was the amount of money that it seemed to be about the same amount of money that Brian Laundrie had taken out of Gabby Petito's account. So yes, there was a wrongful death case, but the wrongful death case can't go to the parents. It goes to the person who caused the death, and the person who caused the death in this case was Brian Laundrie. So that case was brought and was resolved. So let's get to some of the other birthdays. Miss Kimmy, 53 today, spending it with EDB and some Lawnards and some other birthday Lawnards. Hope you and the fam are feeling better today. Allison, we all have the ick over here, and it's going to take some time. So I will tell you when I'm feeling better. It's going to be a minute. I am not well. Teresa said, good morning, Lawnards, coming in from Chile, Wisconsin. Good morning. Good to see you. Today is my 40th, and but we have so many birthdays in the chat today. Lawnards, happy birthday. Christy said, Stanley waiting room got me thinking I'm running late, but I secured the chroma in time. I hope you all got yours. Happy hydrating, Lawnards. Look, the way I was gripped by the Stanley chroma. Look, I will be wrapping my very black car. I love that my car is like black on black. I love a good blacked out situation. You might be able to tell with the Black Facts hat. We've got some black on black sweatshirts coming. Oh my God, I love them. I love a black on black moment. I love a purse with all black hardware, like black on black everything. Love it, love it, love it. But you add a little bit of like an oil slick iridescent. Gripped. I'm gripped. So when I wrap my car, there will be oil slick iridescent accents on the black on black on black. Like all black everything. Just all. What is your favorite color? Black with pink sneakers. My favorite outfit ever. Black with pink sneakers. Beth Aviv said, good morning from 30,000 feet above somewhere in California on my way to the Sino tour, drinking tea. Thank you, Delta Wi-Fi. Delta Wi-Fi has been great for me when I have been popping in from the air as well. When we start the trial for Hannah Gutierrez Reed, there will be one or 2 days that I will be traveling because it is a leap year and Dave Matthews Band is playing in Vegas. And the last time I saw Dave Matthews play in Vegas at the end of February was February 2020. And I feel like I need a do-over. But at that show, Dave played my absolutely favorite song. I think he's played it like 3 times live ever. I have a tattoo of it. And I literally, the first 3 chords of the song started and I burst into tears standing in the pit with my friends who just put their arms around me as I cried. But I need, now that I am over the emotional realization that this is a possibility, I need to experience the concert again where I can actually have my shit together enough to enjoy it and not just absolutely burst into tears because the song I never thought I'd hear live, I heard live. So now I need a whole do-over. So I will be in Vegas. But I think I should have Wi-Fi enough to stream if I need to stream. And because I will be West Coast and the trial is also West Coast. Damn it, it's so much easier when I'm West Coast and it's Pacific. I will do my best. But there might be little bits of the trial that I miss. I'm sure somebody will be covering it. You will not be left alone. Eating my mid-morning donut for second breakfast and drinking water in Corpus Christi. The water cancels the unhealthy donut, right? I mean, sometimes donuts are good for the soul. Prayers for my hometown. Amy Fox, we have sent lots of prayers to Kansas City. So I am continuing. I can't imagine. And I see a lot of you with Kansas City icons in your profile pictures. So could the crumbly verdict affect anything with the Petito Laundrie situation? We have a couple of these, and I'm going to try to bring them all up because I'm going to talk about them all at once. Another one from Linux question: could the crumbly parent case and the Laundrie case affect the legal liability of parenting? I think there's real questions here for those of you that did not follow the Crumbly case. Ethan Crumbly was a school shooter. He was tried as an adult and convicted. Did he plea or was he convicted? He was tried as an adult. He was convicted. I don't remember if it went to jury or not. I do not follow school shooter cases very closely because I have kids that have to go to school every day, and there are realms of mental health that I have to protect myself for. Did he plea? Thank you, chat. I did not follow it super closely. I do not follow school shooter cases very closely. Anyway, tried as an adult. His parents are being tried. His mother was recently convicted by jury, and it was also a first of its kind case. That is going to go up on appeals forever. I don't know and did not closely watch what evidence came in that case and whether or not the law extends that way. So that is a Michigan criminal case holding criminal liability for a underage child. So a under the age of 18 child. The Petito Laundrie situation is civil liability for not the actions of the child, because in the Crumbly case, the responsibility is what the parents may have facilitated or did not stop or did not do vis-a-vis their kid becoming a school shooter. The Laundrie case is a civil case about whether the parents were liable for the statements made. So they are not being held responsible for Brian Laundrie's actions. Brian Laundrie's actions are the circumstances of the situation where the statements were made, but it's over their own statements. The circumstance in Michigan with the Crumbly parents, I think, is going to be on appeal forever. I think it is a very different way to use the law. I've never seen a case like that before. I don't know if we'll ever see a case like that again, but that case is based on parents failing to stop the actions of a child, essentially, versus parents being held civilly responsible for their statements. It's a very different situation. So I did not dive into the Crumbly case. I think others have. I think that lawyer, Peter is covering it. I don't know who else covered it. So it's a very different situation. So no, I don't think what happened in Michigan with the criminal prosecution is even going to extend to other jurisdictions in that circumstance. I think, especially with criminal cases, the facts have to be very, very specific and unique. And I don't think we have any evidence to show that there were anything that the Laundrie parents could have done to have stopped the behavior of their adult son, different than what went on in the Crumbly case, where that was part of the argument about what the Crumblies knew or could have prevented or were obligated to prevent. So it's a difficult case, and I don't know what we will see come from the appeals on that case. We'll see. We'll see. The litigating stopping something is a difficult thing without a very specific fact scenario. If that helps. But no, I don't think the two will overlap on each other. I think what we saw with Johnny Depp being civilly or being sued civilly for the statements of his lawyer, I think that that's an interesting and potentially troubling precedent that we might see, where people are going after the lawyers and going after the parties. I think lawyers are protected from some of that, and then narrowing down the scope of legal employment. I think we're going to see lawyers very finely defining what is part of the gray zone between legal representation, PR, pre-litigation strategy. I think we're going to see a lot of that happening, and a lot of thought lawyers put in around that, and a lot of conversations that lawyers are going to have around that. So I think that the Johnny Depp circumstance is actually something that might illuminate what's going on with Stephen Bertolino more, if that makes sense. I keep saying that today. I'm sorry. It makes me sound very unconfident, but it's none of the legal that we're talking about today is easy. All of it's very mushy gray zone. Candace said, question, can you quickly go over fiduciary duty for everyone in the chat as it applies to morals or not morals involved? This is a very big question, but the fiduciary responsibility of the lawyers goes to their clients. They are obligated to protect their client, regardless of other people. They can't go harm other people to protect their clients, but I don't know if we're here with harm, if that helps. But the lawyers have a duty to their client. The Laundrie parents did not have a duty or obligation to the Petitos. Stephen Bertolino had an obligation to the Laundries, and the Petito's lawyer had an obligation to the Petitos, but the two families did not have an obligation to each other. The legal obligation that the Laundries had was, they can't destroy evidence. They can't mislead the police. They can't lie and try to cover up crimes. Like, there are legal realms of things they can't do, but they're not obligated to speak up and tell the Petitos where Gabby is if they knew that information. Maya asked, could Brian's parents be charged with aiding and abetting for the death? They knew Brian killed Gabby, and they knew he was going to self-harm. I don't know if they knew he was going to self-harm. I can suspect that, but I don't know if we have evidence that they knew that, like, beyond a reasonable doubt. I don't know if they're obligated to stop him. That gets into a really dark conversation about aiding and abetting. But what you're asking about is aiding and abetting after the fact. I don't think there's any evidence that they knew what he was going to do before he did it. And I have a bunch of questions along these lines of aiding and abetting after the fact, obstruction of justice after the fact, and those kinds of things. Did we see them charged? No. Do I think we'll see them charged? No. I don't. I don't think we'll see that at all. So, aiding and abetting after the fact, I don't know if there's anything proactive that they did after the fact. That we have evidence for that would show they aided and abetted after the fact. Or that they knew what he had done and were covering up for it. Helping him hire a lawyer is not aiding and abetting after the fact. It's not legally improper. You're allowed to help someone hire a lawyer. Did they hide anything? Did they obstruct anything? We don't have any evidence of that. There's a lot of suspicions about that, but we don't have any evidence about that. So if they could have been charged, I think they would have been. Sheila said, why didn't anyone have a duty to Gabby? I mean, there's an argument that Brian Laundrie had a duty to Gabby. They were in a relationship. They were engaged. You have a duty, like, not to kill people. It's illegal. But they were adults. So he's obligated not to harm her. He didn't do that. And he would have been held criminally responsible for that were he still alive. But the Laundrie family doesn't have a duty to disclose what they know after the fact. And I don't think they could have stopped it before the fact. Katrina said, I don't like it though, not gonna lie. Katrina, totally fair. Absolutely fair. It's not an easy conversation to have because of the levels of, I don't like it though. I get it. Absolutely get it. Could the Petitos have made an agreement with the Laundries that they wouldn't sue them if they would have been honest with them? I don't think that was the concern at the time. I think the concern at the time was criminal responsibility. So I think the concern of the Laundrie parents were whether or not there would be criminal liability. So they could say, we're not going to sue you, just tell us. But that doesn't mean that they're not going to tell the police. And that doesn't mean that Brian Laundrie wouldn't get prosecuted. So I think that was the bigger problem. Enchanted Wings said, this is an incredibly hard case. It is. Thank you for covering it. You're welcome. I think it's a really important case to talk about, even though it's difficult. Conical Heart, thank you for the gifted memberships. I appreciate it. Dawn, good to see you. Can't wait to hear more on Housewives, Becky Boo, and COS. We're trying to balance the criminal cases, the civil cases that are tangentially related to criminal things, for sure. Trying to balance it. Let's see. Congratulations on everybody celebrating their anniversaries in the chat. Thank you for covering this fascinating and important case. Can you please talk about how you keep the feelings out of it when the whole thing is about emotional distress? Crispy Cookie, I try to acknowledge and separate my own feelings from it, so that my own feelings about it don't impede my judgment, or at least I can tell where they are. And if I can tell where my own feelings are, I can know how I'm processing the information. And yes, the case is emotional distress, but my feelings about the Laundrie's behavior should not tint or taint my opinion about whether or not this is a legally sufficient case to go forward just because I don't like it, right? So emotional distress and the causation of emotional distress is about the harm in the case, but my feelings about the case and my feelings about the Laundrie's behavior doesn't mean they're legally liable for something just because I fucking hate it. Hopefully that makes sense. Dexter asked, do we have Ruby Frankie sentencing next week? Yes, we do. The Frankie sentencing and the Hildebrandt sentencing are both on February 20th. So we will be doing that day. Now's a good time for me to remind you that if you don't have the Law Nerd app, download the Law Nerd app, because timing as we get into another live trial and timing as we cover sentencing in live court is not always going to be neatly at 11 a.m. So if you don't want to miss a thing, Law Nerd app will get you there. Giselle said, loved watching you on Housewife and the Hustler. So interested to hear more of your thoughts about the Marco stuff. That was the craziest part for me. I didn't cover the Marco case much when it came out. But I think I will add it in. For those of you that are like, wait, what? The Housewife and the Hustler part 2 is out on Hulu. I participated in it by giving legal commentary. There is a lawsuit going on with Erica Girardi and people who are costume designers, like Emmy Award-winning costume designers in Los Angeles. They're alleging that she had them indicted improperly by the FBI and the U.S. attorneys over false statements she made when she wore a wire, and that she used her influence and Tom Girardi's influence. And then ultimately the prosecution was just magically poofed into thin air. It's a wild case. I have not covered it much. We might need to do that. So hopefully that helped. I got the dragon mug on Parse. Autumn said, I got the dragon mug on Poshmark, searched forever. Yeah, these were at all of the Starbies. And then they weren't. Then they got popular and they were gone. But I really enjoy the iridescent ear of the dragon mug. I'm a sucker for anything iridescent. Look, man, if you make it iridescent and hollow, I will be a magpie and be like, yes, I need it immediately. I need a better iridescent phone case. Like, I kind of love my phone case, but this is why I wear everything black. So my phone case now is like, from going into my workout pant pockets, is now not cute and pink and bubbly. So I kind of need an iridescent phone case. For all those asking, did I get the Chroma Stanley? Yes, I did. Matt Bond, good to see you, friend. For the record, on the record, let the record show. Hello, Spiffy Legal Mumbo Jumbo, talkie sister from another mister. Floofy says meow. Boop the floof for me, Matt. Good to see you. Alley Cat asked earlier, my birthday is in 4 days. Can I get a goat? Can absolutely get a goat. Where is my goat? Can absolutely get a goat. Happy birthday. Kiki in the chat said, is that a dragon? I thought it was a deer. It's a moose. It's a moose. No, it is a year of the dragon. It is a year of the dragon mug from Starbucks. And I don't want to show it too much because it has all the dregs of my coffee in it, but it is an iridescent year of the dragon mug from Starbucks. I thought it was adorable. It is perfect for my morning coffee. Is advice of counsel a defense for the Laundries? I mean, they're arguing litigation privilege. So they're arguing that the statement was made in anticipation of litigation or preliminary in litigation. That's kind of where they're putting that. But like, our lawyer told us not to say anything, would have sufficed for them not speaking, but then we wouldn't be here. Is it plausible that they knew, but the lawyer didn't? It is, Heather. But if we're imparting knowledge based on what they said, they're saying they didn't know, right? So if a jury believes them, then that's that. They're saying they didn't know, but then they asked Bertolino to help find a criminal attorney in Wyoming. Why are you hiring a criminal attorney in Wyoming? That's something that a jury can decide. Lacey said, wishing my coworker Patty love and healing. Her husband passed suddenly from a heart attack. Huge shock because he was a very healthy and active guy. Lacey, I'm so sorry for Patty's loss. That has to be completely shocking. And I'm sure that y'all have a wonderful community to surround her with love during a very disorienting time and making sure like she gets fed. Feeding people is how I deal with grief. So that is where I default to. I never know what to do with myself. And like grief dregs up other grief, which is wild. So I just try to feed people. I'm like, you probably need to eat, hydrate. Like, I don't know what to do with myself. Just, can I clean your house? I don't know what to do with my hands as people are grieving. So I try to hug them and bring food. I don't know what to do. If anyone has other suggestions, I'm always open for them because I always feel like, what else do I do? Happy 1 year anniversary. My mom's birthday was yesterday. Valentine's baby, 55 years young. My husband's grandmother is a Valentine's Day baby. I chose for Griffin not to be a Valentine's Day baby. My doctor was like, so this day or this day, and I'm like, not Valentine's Day, but my husband's grandmother was a Valentine's baby. Then she and his grandfather got engaged on Valentine's Day, and then they got married on Valentine's Day. So by the time I came into the family and was dating my husband, I looked at his grandfather and I'm like, so you're telling me that your wedding anniversary, her birthday, and Valentine's Day are all the like just the one day a year. You just do everything on the one day of a year. And he's like, well, I'm never gonna forget. Like this is the this is the funniest thing. Just well, I'm never gonna forget wedding anniversary, Valentine's Day, birthday, done, done, done. He's like, I'm never gonna miss it. I'm like, but it's just once. But it's just the one day. But it's just the one day. Sean C. Kate said, I would speak up and turn my child in. I would want any parent to do the same for my family. At least I would be able to visit my child. And I think a lot of you in the chat have expressed the exact same feelings about this case. Stephanie King, question, does the law invite consideration of morality with the verbiage, the conduct was outrageous because emotional distress, emotional severe? It absolutely does. It absolutely does invite the conversation of like, what are the bounds of decent society? That's very much jury language. Like, does this rise to the level of outrageous? Absolutely does. Absolutely does. Shiraz, thank you for the gifted memberships. Walkie Talkie said, I wish I were positive that I would say something immediately because it's awful. But would I, if it were my daughter? I'm just being honest. I feel slimy saying it out loud. Walkie Talkie, first of all, thank you for saying it out loud. This is a place to have these conversations because I don't think you ever know what you're going to do. And if a lawyer is saying what you can't do is say anything, I don't know what you do in that situation. Like I get it. I'm also, the one who would, I was sometimes such a pain in the ass in my younger days. But if I saw people who had what I considered to be drinks, I was always like grabbing the car keys and people were like, I'm taking my car keys, I'm going. I'm like, I'm going to just call the cops on you. Just so you know, you're going to get pulled over for DUI. Just like, because I can't let you go do that. And if I can stop you, I'm going to. And if you insist on leaving, I will call the cops on you. Did I do that? Yes, I did. Yes, I did. Look, you never know what you're going to do. Is that a very different situation? Yes, it is a very different situation than wanting to protect your kids. I don't know if anyone can say what they would do. You can say what you would hope you would do. And you would hope you would do, like, you would hope you would never be in that situation. And you would hope you would do the right thing. It's a hard thing. And I think it's hard to have the conversation in real time because people are trying to process, like, we're trying to make logical decisions and have a conversation about logical decisions. And we're trying to have a logical conversation, but they were in the most emotional situation. And people don't always make good decisions when they are in that fight or flight emotional. Like, it's hard to say what you would do. Like, can I take this out of this context that's so dark and say, I would love to think that I would be great on The Amazing Race. Like, I'm going to make a different analogy and talk about something else. I love to think I would be great on The Amazing Race. Like, I love to think that I could do that. But I also know myself. And if I was hungry and stressed and trying to like book flights across the world, would I be a screaming maniac? Probably. Would I be able to logically think through and problem solve when I am hungry and tired? Probably not. I would probably be fucking terrible. But I like to think that I could. But like, my back would start to hurt after a couple of those flights or throw me on a train for like 10 hours and I would lose my mind. I am too bougie and needing of comfort to actually be good on The Amazing Race. So do I like to think I would? Yes. Would I just break down into tears because I was hungry? Probably. I would be like not hydrated and needing to find a bathroom and fighting with Dr. B. Could Dr. B do it better than me? I think Dr. B would be better than me at it. But I think I would be a mess. I really do. If I had to eat squishy food, like, ooh, like no. I have sensory issues. Like when I fly, I need like my noise canceling headphones and my eye patch. I do not do well booking. I've booked travel to the wrong state, sitting in my house under no duress. That alone tells you I would be bad on The Amazing Race, but I love to think that I would be great. But I wouldn't. I wouldn't make decisions in that emotional state. And that's why those shows are so interesting to watch, because people are in a constant state of like fight or flight. And then your logical brain doesn't work well. And some people do better and some people don't. So the level of the the level of decision making under duress and under stress is different. So I don't know. Trying to take it out of a very dark circumstance to talk about it in a very light circumstance and how you would make decisions. I don't think we always know how we'll make decisions when we are stressed. We would like to think we could do a good job. I would like to think I could. My cat is obsessed with your stream. Hello, Lynn's cats. I appreciate it. I've heard that from lots of you. Lori said lost empathy for the defense when they argued that returned did not mean alive. They should have let the Petitos know where to look, in my opinion. And again, Lori, allowed to have your opinion. Appreciate you sharing them. Because you guys do such a good job of sharing your opinions with like, hey, it's my opinion, I think this. EDB, if you don't sing at least a few songs, you'll get the pressure build up and it'll hurt your brain. I'm starting to feel that now. I'm starting to feel under pressure. I am. Inga said, so to cover up for murder is okay if you are a lawyer in the US. Inga, I don't necessarily think that's what's happened here. They're arguing they didn't know there was a murder and that they are not covering up for it. But no, covering up for a murder, if you are legally covering up for a murder, could be aiding and abetting after the fact. However, if you are the defense attorney hired to represent the person who's accused of doing the murdering, the obligation is to the client and not to anyone else. So can a criminal defendant tell a criminal defense attorney what happened, where a person is? Out of this scenario, could a serial killer tell a criminal defense attorney, hey, there's these bodies that law enforcement hasn't found. And so just so you know, there's maybe some things that you need to be aware of. Can that lawyer tell anybody? No. Is that lawyer's job to tell anybody? No. That criminal attorney's job is to protect their client. So if they came to the lawyer and were like, can you tell us where the bodies are? The lawyer is going to say no. And that's after the fact. If a lawyer is aware that somebody is going to commit a crime, it's different. Hopefully that helps. Glad to keep you company on your road trip. LJ Peach said you can't legislate morality. And it seems his parents are morally bankrupt. I mean, that's what the Petito said. Sue, thank you for the love. Emily Henning said, question, do you think they're really doing this for money? I don't. Or is the lawsuit more about trying to get information so they can try to understand what happened? I think a lot of it's about getting information, Emily, and I think some of it is about being told that they're right, being told that this behavior is not okay, and being told that they're right. Having someone else say to them, you're right, these people shouldn't have done this to you. And you're right. There's 6,000 people in the chat who I think are like, you're right. No one should have done this to you. This shouldn't have happened to you. You're right. But I don't know if it is legally actionable. So, I agree with you, Deborah. There's no way to repair the betrayal and the grief. I don't think there is. We're happy to accompany you to the dentist. I hope it was great. Emily, what about the word reunited? The attorneys are going to be in the unenviable position of arguing that word has multiple meanings. Yep. I don't want to be in that position. Let's see. Liarbird said, what's illegal is the lowest bar of appropriate behavior. We should hold people to higher standard, but that doesn't make not meeting it illegal. Yeah, it doesn't make them liable for it. Question, do you think this will actually go anywhere? I don't see them having a case anymore. Natalie, I'm going to be really interested in the responses and the arguments for the motion for summary judgment. I think the case against Bertolino is harder. Why the Laundries didn't get charged on obstruction of justice? Alco, I don't think we have any evidence that they obstructed justice. They don't have to say anything. And you can't charge somebody for obstruction for not saying anything. Emily, what are your thoughts about the Laundrie family taking the camping vacation trip in the middle of this? It didn't sit well with me, but I think they were also trying to say goodbye to their son. That's what it felt like. Like they knew that everything was going to change. I don't know if they knew he would take his own life. I don't think he knew. I think they probably assumed that he would go to prison. So it did not sit well with me. But were they not allowed? They were allowed to go do it. They could do whatever they wanted. At that point, Brian could have left the country. He hadn't been charged in anything. He could have left the country at that point because he wasn't charged. I don't like it. Jenna P said, question, shouldn't Brian have been arrested for Grand Theft Auto? I don't think they could have arrested him for Grand Theft Auto, and here's why. He had a right to be in the vehicle. We're just doing a legal analysis. He had a right to be in the vehicle. They were engaged, even though it was her car. And there was no evidence that she reported that he wasn't allowed to have the car. Now we know that that's the case because he had killed her. But I don't think they could have arrested him for Grand Theft Auto. The only thing that they put out for him before, because I think they were worried he was going to run, was the unauthorized use of her debit card. I think that's the only thing they had. And they were trying to arrest him on the unauthorized use of the credit card so he couldn't run. At that point, he was already missing. And I think at that point, he was already deceased. Ava said, didn't they help clean out the car? I don't think the car was a crime scene. So even if they did help clean out the car, I don't think that the car was the crime scene. And I don't think there's any evidence that it was. Question, if evidence comes up in the civil trial that they obstructed justice, can it lead to criminal charges? Sarah, I think it would have come up by now, but it's always a possibility if something new is uncovered. I would have to look at the statute of limitations, though. Toya, did he ever say why she was murdered? He had a very interesting note. That note I've covered on this channel, and it was covered on WFLA. You can go read it on the internet. He didn't really say. Didn't really say. Shirley said, question, if Brian and Gabby had been legally married, would Brian's parents have a responsibility to Gabby's family? No. Or would anything else change? No. I mean, his obligations to her, like financially and tax-wise and stuff would have changed, but no, nothing in this scenario would have changed had they been married. Could Brian's parents be charged with aiding and abetting for the death? They knew Brian killed Gabby and they knew he was going to self-harm. I know that we answered that, so I hope that answer was clear. Lindsay said, it's my birthday. I can't decide if I want sushi or a BLT for dinner. Thanks. The chat said sushi. I also am a person who used to love a BLT, but I'm allergic to tomato. So I say sushi. Sushi sounds good. Let's see. Regina Celia Rodriguez said, EDB in a civil trial, how would the instructions for the jury be in such a case? We can go over jury instructions as we get closer, but it would be like the Depp Heard case. You would get jury instructions on what the standard of proof is, the preponderance of the evidence, what the charges are, the IIED. You would break down the 4 different parts of the IIED, those kinds of things. So, thank you, Lori. Hypothetically, from Maddox Mickey, if the Petitos prove the Laundries knew that Gabby was deceased, does that open the Laundries up to aiding and abetting charges? No, it doesn't, because I don't see anything they did after the fact, even if they knew. I don't have enough evidence on action after the fact. So we might need action after the fact for that to be the case. It will help their argument here. Let's see. True Crime Curator, EDB is pretty much the best thing available on any platform. Thank you so much. I'm here to help. I appreciate it. Wolfheart, EDB, can I get a shout out for my 21st birthday on Saturday?
Wolfheart, happy 21st birthday on Saturday. Hydration is key. Don't forget to eat. You don't have to drink all the things at once. If you're inclined to drink the things, don't mix drinks on the 21st birthday. It's not a good thing. And hydration before and after. Those are all my tips. Have a happy and safe 21st birthday.
It's very exciting. Let's see. Emily, why are you not on the Streamer Awards? What are the Streamer Awards? Cup butter. And how can one nominate a streamer? I have no idea. I think the funny thing is, though, I am one of the bigger streamers on the platform, that people forget that I'm a streamer, A, due to my age, B, due to the fact that I've never streamed on Twitch, and C, due to the fact that I do legal streaming. I think people just forget I exist. YouTube doesn't, but I think others do. But I don't know the Streamer Awards, so I can't quite tell you. You guys, I'm going to have to get going in just a second. Allison, thank you for the love for this community. I love y'all too. Gifted 10 EDB memberships. Thank you. I need to talk to YouTube. What I'm going to need is like shiny oil slick like gifs and like emojis. How much of the laundry statement has to be a partial causation for the Petito family to be given partial judgments? 51%. So, unless the rule is different in Florida, but it's generally more than half. I mean, I guess because you wouldn't be liable if it was under 50%. Like, I don't know if they can find it caused 10% of their grief. I would have to look at that though, about the way they could apportion out, which is why civil can be so weird. The way they could apportion out the causation in Florida, I would need to look. MB said, if you know someone has killed someone and you help clean up, well, that can be illegal. I mean, helping clean up after the crime can be illegal. Like I don't want to help people crime better. That could be illegal. So aiding and abetting after the fact is different. But the crime scene that we're talking about in this case is in Wyoming. And there's no evidence that they went to Wyoming and helped make it harder to find Gabby Petito's body. So with all of that, I hope that helps. I know it's frustrating. I understand the deep desire to hold somebody responsible. I understand that. I just don't know if this lawsuit is going to do that, because the responsible party, the person responsible for the murder of Gabby Petito, is dead. There's not much else that can be done to hold him responsible. And that feels unresolved. And I understand that. So with all of that, law nerds, thank you for walking through the difficult civil discussions. Today we had a full like law school type discussion of cases. And this is the kind of stuff that's discussed. Does the law encompass this behavior? Does it not? Should it? Should it not? Where are the boundaries of legality and morality? Where are the boundaries of behavior that feels outside the norms of civilized society or not? I don't know. And with that, to everybody who's celebrating their birthday in the chat, happy birthday, chat. Happy birthday, Amy. You guys know Amy has a YouTube channel. Go show some love. You're going to learn a whole lot. Amy has lots of teachable moments. You're going to be shocked at some of the things she has to teach. I constantly am. Amy, I adore you, friend. Have a wonderful birthday. I hope you guys, if you want to show Amy the birthday love, you can go subscribe to her YouTube channel. I'm just saying, you will learn a lot, and she's real fucking funny. So with that, law nerds, thank you for being here. Thank you for being law nerds. I hope that everybody who got everybody who wanted a Chroma Cup got one today, and I will see you in the next one. Law Nerd app is where I'm going to keep you in the loop for the next few weeks, because things are going to get weird with travel and trial and things. So if you haven't downloaded it, it's free. Go do that now. Bye, guys. You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday, for when you just have time for the quick bits. Thanks for being a Law Nerd.